Sir, voice ಕೇಳಿಸ್ತಿದೆ sir?
ಕೇಳಿಸ್ತಿದೆ sir.
Yes sir, please.
Announcement of judgment, serial number 1.
Please, my lords, I am appearing for the appellant one.
For respondent.
The appeal filed by the accused is allowed. The judgment of conviction dated 25/6/2019 and order of sentencing dated 4/7/2019, passed in SC number 34 of 2017 by the Principal District and Sessions Judge Gadag, is set aside. Since the accused is already on bail, by the order dated 2/11/2020, no further direction is required to be issued.
Obliged, my lords, highly obliged. Obliged.
Number 2. Recess.
Please, my lords, I appeal for the appellants in this case, my lords.
Even though the judgment is not ready,
Please, my lords.
there must be result anta.
Serial number 3. J. Shetty and connected matter.
Please, madam. I am for the respondent number 1.
ಏನಾದ್ರು ಸ್ವಲ್ಪ ದಿನ ಆಗುತ್ತೆ ಇದು. ಮೇಡಮ್ ಸ್ವಲ್ಪ ಬಿಸಿ ಇದ್ದಾರೆ ಇವಾಗ. We'll only say halt and result. Halt further result.
Serial number 4. DB Karigar and connected matter.
May please, my lords.
Halt further and result.
Appeal for the appellant, my lord.
Yes, Mr. Dali.
Much
We'll take it as it is halt further.
Court officer, madam.
Hello, sir. Sir, Dharwad bench in the.
Court officer.
Hello. Court officer. Madam, ನಾಲ್ಕು minute ಏನಾಯ್ತು?
Background. Change ಮಾಡಿ. Court officer. Court officer, sir. Hello. Court officer, sir. Hello.
ಯಾರು ಇಲ್ಲ ಮೊಬೈಲ್ ಮಾಡ್ಬಿಟ್ಟು
Court officer, sir.
ಹೌದಾ?
ಗುಲ್ಬರ್ಗ ಫಸ್ಟ್ ಆಮೇಲೆ ಕೆಳಗಡೆ
Sir, court ಅಲ್ಲಿ 18
ಆಮೇಲೆ
Hello.
ಅವ್ರು ಒಂಚೂರು ಕರೀರಿ ಕನೆಕ್ಟ್ ನೋಡಿ ಏನ್ ಕಾಣಿಸ್ತಾನೆ ಇಲ್ಲ ಸ್ಕ್ರೀನು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಮೇಡಮ್ ಕೇಳ್ತಿದ್ಯಾ? ಹಲೋ
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಕೋರ್ಟಲ್ 18 ಅಲ್ವಾ?
ಹೌದು ಸರ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 25 ಮೇಡಮ್.
ಅದು 2:15.
2:15 ಓಕೆ ಮೇಡಮ್.
ಇನ್ನು ಕರೆದಿಲ್ಲ ಸರ್.
ಹಲೋ ಮೇಡಮ್ ನಮಸ್ತೆ. ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹೇಳಿ ಸರ್.
ಇದೇನ ಜಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಮೇಡಮ್, ಏನಾಯ್ತದು?
ಯಾವ್ದು ಧಾರವಾಡದ ಮ್ಯಾಟ್ರಾ?
ಧಾರವಾಡ ಮೇಡಮ್.
ಸರ್ ಮತ್ತೆ ರಿಸರ್ವ್ ಮಾಡಿದಾರೆ ಸರ್.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
Hello, court officer.
Hello, ma'am.
Hello, court officer.
ಹೇಳಿ ಸರ್.
ಸರ್ ಇದು ಗುಲ್ಬರ್ಗದ 230 ಲಿಸ್ಟ್ ಫಸ್ಟ್ ತಗೊಳ್ತಾರಲ್ಲ?
ಗುಲ್ಬರ್ಗದ
ಹೌದು.
ಇದೆ ತಗೋತಾರ.
ರೈಟ್.
ನೋಡಿ ನಾಗರಾಜ್ ಆಚೆ ಇದ್ದಾರಾ? ಬೇರೆ ಕೋರ್ಟ್ ಕನೆಕ್ಟ್ ಮಾಡಕ್ ಬಂದಿತ್ತಲ್ಲ. ಅವ್ರಿಲ್ಲ ವೀಣಾ, ಈ ಕೋರ್ಟಲ್ 18ಗೆ ಯಾರು ಬರೋದು ಅಂತ ಸ್ವಲ್ಪ ಕಳ್ಸಮ್ಮ ಅವ್ರನ್ನ. ಫೋನ್ ಅಟೆಂಡ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅವರು. 2 ಕಾಲಕ್ಕೆ ಸಿಟ್ಟಿಂಗ್ ಇತ್ತು.
Court officer, madam.
ಮೇಡಮ್
ಸರ್ ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಅದು ಲಿಸ್ಟ್ 2 ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್ 1 ಫುಲ್ ಕಂಪ್ಲೀಟ್ ಆದ್ಮೇಲೆ ತಗೋತಾರಾ ಮೇಡಮ್ ಅಥವಾ ಆರ್ಡರ್ ತಗೋತಾರಾ ಮೇಡಮ್?
ಒಂದ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಒಂದ್ ಲಿಸ್ಟ್ ಸರ್.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಇಲ್ಲ ಏನ್ ಬರ್ತಾನೆ ಇಲ್ಲ. ಧಾರವಾಡ ಅಂತ ಆದ್ಮೇಲೆ ಈಗ ಬೆಂಗಳೂರು ಕನೆಕ್ಟ್ ಆಗ್ತದೆ. ಅದೇ ಫೋನ್ ಮಾಡಿದೀನಿ, ಅಲ್ಲಿಂದ ಬರ್ಬೇಕಲ್ಲ ಅವ್ರು.
ಮೇಡಮ್ ಧಾರವಾಡ ಮ್ಯಾಟ್ರ್ ಎಷ್ಟಿದೆ?
ಆಗೋಯ್ತು ಸರ್ ಅದು.
ಮುಗಿತಾ ಈಗ ನಮ್ದೇ ಬೆಂಗಳೂರದಲ್ಲ ಲಿಸ್ಟ್ 1?
ಹೌದು. ಕಾಣಿಸ್ತಿದ್ಯಾ ಸರ್ ಫೋಟೋ? ಕೇಳಿಸ್ತಿದೆ, ಕಾಣಿಸ್ತಿದ್ಯಾ?
ಕಾಣಿಸ್ತಾ ಇದೆ ಮೇಡಮ್, ಕಾಣಿಸ್ತಾ ಇದೆ.
ಸಾಹೇಬ್ರು ಡೆಸ್ಕ್ ಸರಿಯಾಗಿ ಕಾಣಿಸುತ್ತೆ,
ಹಾ ಹಾ.
ಸಾಹೇಬ್ರು ಬಂದು ಕೂತ್ಕೊಂಡ್ಮೇಲೆ ಸರಿಯಾಗಿ ಕಾಣುತ್ತಾ ಅಂತ ಗೊತ್ತಾಗುದಿಲ್ಲ.
ನಾನ್ ಕಾಣಿಸ್ತಾ ಇದ್ದೀನ ಸರ್?
ನೀವು
ಸ್ವಲ್ಪ ಕಾಣಿಸ್ತಾ ಇದ್ದೀರಾ?
ಅರ್ಧ ಕಾಣಿಸ್ತಿದ್ದೀರಾ?
ಇಲ್ಲೇನು ಗೊತ್ತ. ಟಚ್ ಮಾಡಿ ಏನಾದ್ರು ಕಾಣೋ ತರ ಮಾಡಕ್ ಬರುತ್ತೆ. ಆಗಿದೆ ಸ್ಟಾರ್ಟ್, 2 ಸಲ ಸ್ಟಾರ್ಟ್.
ಹಲೋ ಮೇಡಮ್, ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಇದು ಗುಲ್ಬರ್ಗದ ಒಂದು ಲಿಸ್ಟ್ ಇದೆಯಲ್ಲ ಮೇಡಮ್, 230 ಲಿಸ್ಟ್. ಕಲಬುರ್ಗಿದು ಮೇಡಮ್.
ತಗೋತಾರೆ ಸರ್ ಒಂದು ನಿಮಿಷ. ಆಯ್ತು. ಸರಿ ಸರಿ.
This meeting is being live streamed. What?
Good afternoon, Yesu Mishra. What to do?
ಯಾವ್ದು ಬೇಕು ಅಂತ ಹೇಳಿ.
ಇದೆ ಮೇಡಮ್, ಇಲ್ಲ ಇದೆ, ಕಾಣಿಸ್ತಾ ಇದೆಯಲ್ಲ, ಇಲ್ಲ ಇದೆ ಲೈವ್ ಆನ್ ಯೂಟ್ಯೂಬ್ ಕಾಣಿಸ್ತಾ ಇದೆಯಲ್ಲ. ನೀವು ಹಂಗೆ ಚೆಕ್ ಮಾಡ್ಕೊಬೇಕಂದ್ರೆ ಬ್ರೌಸರ್ ಓಪನ್ ಇಲ್ಲಿ ಬ್ರೌಸರ್ ಓಪನ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಸ್ಟಾಪ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಡಿಸ್ಟರ್ಬ್ ಆಗತ್ತೆ. ಎರಡೇ ಸತಿ ಕೇಳ್ಸುತ್ತೆ ಇದು ಅಲ್ಲಿ ಮಾತಾಡೋದು ಇಲ್ಲಿ ಬರುತ್ತೆ. ಓಪನ್ ಆಗುತ್ತೆ ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ಓಪನ್ ಆದ್ರೆ ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ಆಗಿದ್ದಾನೆ. ಇದು 17 ಅಲ್ಲ, ಇಲ್ಲಿ ಐಫೋನ್ ಇದೆ ನೋಡಿ, ಇಲ್ಲಿ ಐಫೋನ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿದ್ದೀನಿ. ನಮ್ದೇ ಪ್ಲೇಯರ್.
ಅಲ್ಲ ಟೈಪ್ ಆಗ್ಬೇಕಲ್ಲ. ಫೋನ್ ಮಾಡಿದ್ದೀನಿ.
Submission. Secondly, we'll come to that. First is Kalburgi matter.
My lord, I'm praying for the petitioner in this matter, my lord.
Yes.
My lord, I filed application for correction of order, my lord.
Yes, Mr.
My
Chaitanya,
lord,
what
I'm praying for the petitioner in this matter, my lord. I filed application for correction of order, my lord.
is correction?
My lord, in paragraph 3, my lord. Lord, fourth line, Lord, instead of my lord respond number 6, it has to be typed as respond number 5, my lord.
Para 3, fourth line, respond number 6 agide, respond number 5 agbe.
ಹೌದು ಸರ್. ಪ್ಯಾರಾ ನಂಬರ್ 12 ಅಲ್ಲಿ
ಆಮೇಲೆ
ನೋಡಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 12 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 ತಹಸೀಲ್ದಾರ್ ಮಾನ್ವಿ ಬದಲು ಅದು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 ತಹಸೀಲ್ದಾರ್ ಕಲಬುರಗಿ ಅಂತ ಆಗ್ಬೇಕು ಸರ್. ಎರಡು ಕಡೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6 ಇದ್ದದ್ದು 5 ಅಂತ ಆಗ್ಬೇಕು ಸರ್. 7th ಲೈನ್ ಅಂಡ್ my lord second line in 8 page number 8, my lord.
Yes. IA number 1 of 2021 has been filed seeking for correction of certain typographical errors which have crept into the order dated 24/2/2021 passed in the above matter. Accepting the reasons stated in the said in the affidavit in support of the said application, the following corrections are directed to be carried out. In para 3, line 4, the numeral respond number 6, the numeral 6 after respond number directed to be replaced with the numeral 5. In para number 12, the word Manvi, M-A-N-Y, is directed to be replaced with
respond number 3 ತಹಸೀಲ್ದಾರ್ ಕಲಬುರಗಿ.
Kalburgi. Line number 7, the numeral 6 is directed to be replaced with the numeral 5. In para number 12, page 8, line 2, the numeral 6 is directed to be replaced with the numeral 5. After carrying, registry is directed to reissue a fresh certified copy after carrying out necessary corrections.
Lordship's submission.
How is it? Which one are they? 20 to 24. These two not together. B group 20 to 24.
Serial number 24 in the list number 1, my lord. 24. I pray for a week's time in this case, my lord.
Have we informed the counsel for the petition?
Yes, my lord. He is also online, my lord. Mr. Anil Kumar is also online.
Please, my lord, I am for the petitioner, my lord.
Any objection?
No, my lord.
Mentioned at 2:30, learned counsel for the respondent seeks for 2 weeks accommodation. There is no objection by the counsel for the petitioner.
Date may be given, my lord.
Relist on 10-3. In all matters, date will be given with
My lord, serial number 25, my lord.
Serial number
25.
25
Yes,
ಅಲ್ಲ. Page 5 ಅಲ್ಲಿ ಏನಾರು ಇನ್ನೇನಾರು ಇದೆಯಾ? ಹೇಳಿ 25.
Swami, 2 weeks time ಕೇಳ್ತೀವಿ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
ಯಾರಿಗೆ?
ಅದೇ for petitioner ಸ್ವಾಮಿ.
We inform the respondent.
Your
Will
Lord.
inform ಸ್ವಾಮಿ.
This matter is infructuous as a suit has been disposed for non-prosecution.
In which matter, madam?
25, Your Lordship, serial number 25. I appear for response 3 and 4.
Yes. Suit is disposed.
Dismissed for non-prosecution, Your Lordship.
Mr. Rafi, the suit is dismissed on 23/8/21. 25. Learned counsel for the respondent submit that the suit is being dissued in verse number so and so, which the above petition arises out of has been dismissed on 23/8/2021. Accepting the said submission, the petition is dismissed as infructuous. Both.
Serial number 26, my lord.
Yes.
For 26, I represent petitioner, my lord. Kindly 2 weeks time, my lord.
ನಿಮ್ಗೆ ಏನಾಗ್ಬೇಕು? ಹಾ. ನಿಮ್ಗೂ ಟೈಮ್ ಬೇಕಾ? Both the counsel
number 9 to 12, my lord.
Yes, madam.
Respondent number, no, my lord, I have no objection.
26. Both the counsel for the petitioner and respondent number 1 seek for a short accommodation. Relist on 15/3.
My lord, kindly extend interim order, my lord.
Interim order granted earlier is extended till next date.
Much obliged.
Lordship's kind permission. Serial number 37, my lord.
ಒಂದು ನಿಮಿಷ. 34. ನೀವು ಯಾರಿಗೆ? Have you informed respondent?
I appear for the respondent, my lord.
ಮಾಡಿದ್ದೀರಾ? Respondent.
No objection, my lord.
34 mentioned at 10:30. Learned counsel for the petitioner seeks for 2 weeks time. Relist on 16/3. Interim order earlier granted is extended till next date. Yes, madam.
Serial number 37, my lord.
ಹೇಳಿ.
The connected matter 37474, my lord, is listed on 23rd, my lord.
37474
of 2017.
2017. Mr. Harish?
It is listed on 23rd, my lord.
Yes, Mr. Harish?
Harish is aware about it.
23rd. Number 30. Registry direct connect WP number 37474 of 2017 with the above matter and relist on 23rd.
My lord.
Yes.
Interim order, my lord. Interim order.
Interim order earlier granted is extended till next day.
Obliged, my lord.
Why, Mr. Gopal Krishna? ಏನಾಯ್ತು? ಸೂಟ್ ಏನಾಯ್ತು? Miscellaneous petition. Then Sri Gopal Krishna, learned counsel for the petition, has filed a memo seeking for withdrawal of the above petitions on the ground that the said petition has become infructuous on account of the miscellaneous petition having been disposed. Accepting the said memo and the submission of Sri Gopal Krishna, the petitions are dismissed. Separate orders. Yes.
Not serial number 11.
Number 14, my lord. Yes. Till number 14. Yes. The respondent. Kindly have it. Next week. Petitioner. Petition is 13. ನೀವು ಯಾವ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ? ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ ಇಷ್ಟೊಂದು ಜನ ಇದ್ದಾರೆ, ನೀವು ಯಾವ ರೆಸ್ಪಾಂಡೆಂಟ್? ನಂಬರ್ 4. Mission 230, learned counsel for the respond number 4 seeks for the short accommodation. Sorry, respond number 2, my lord. Respond number.
I appear for 3, 4, 5.
Only 2, 2 and 5 ಅಂತಿದೆ. 14, serial number 14. 14. ಇನ್ನ ಬಂದಿಲ್ಲ ಇದು. ರವಿಕುಮಾರ್. ಒಂದು ನಿಮಿಷ ಇದು. Page number 3, any other submissions?
My lord, serial number 11, my lords. I appear for the
Yes.
petitioner. My lords, there's a slight
Yes.
inconvenience today. I humbly request 1 week's time, my lords. I'll address the court.
Lord, I appear for the respondent. A date may be fixed, my lord. It's a short matter on appointment of a commissioner only.
Please, my lords, I do not intend to seek more time. It's just an inconvenience today, my lords.
Mentioned at 2:30, learned counsel for the petitioner seeks for a week's time on the ground of personal inconvenience. Learned
My lords,
counsel
a
for
short
the
date may be granted, my lords.
Learned counsel for the respondent has no objection as long as the date is fixed. Released on 2/3/2022.
Please, my lords, interim order may be extended.
Interim order earlier granted is extended till next week.
Obliged.
You are the 14, Mr. Ravi Kumar. You are for respondent number 2, na? 14. Learned counsel for mentioned 2:30. Learned counsel for respondent number 2 seeks for a short accommodation. There is no opposition on part of the counsel for the petitioner. Released on 14/3.
Lordship, serial number 15, my lord.
Yes.
Which I seek for 2 weeks of accommodation.
Where is the petitioner?
Lordship. Inform him.
Counsel for the respondent seeks for 2 weeks. 2 weeks time. Released on 17/3.
Serial number 8. Serial number 18.
Aid not eligible for mentioning. B group ಮಾತ್ರ preliminary hearing ಎಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡಿ. ಯಾರು ಇಲ್ವೇ ಇಲ್ವಾ? 8. Current counsel for the petitioner seeks for a week's time. Released on 28.
For the appellants, my lord.
For the respondent, man. This affidavit is filed?
Yes, I have filed.
My lord, I have a short submission to make with respect to the affidavit filed by my learned friend, copy of which has been served on me on the last week. The gist of the affidavit is not in the spirit of the order passed by this honorable court. It is drafted in a very casual manner without observing the direction of this honorable court, my lord.
Madam, don't make any comments on drafting. You say what is your contention.
My lord, my submission is that
Drafting goes somewhere else. Please don't do all that.
my submission is that with respect to para 2 of the affidavit, the learned counsel for the learned chief officer for the respondent number 3 has made a mention that mention of the facts of the case, my lord. And the second contention, my lord,
Mr. Shetty,
there is no undertaking
Mr.
with respect
Shetty.
to.
This affidavit was to be filed as per your contention, not as per the court direction.
My lord, affidavit is
If you
with
don't
respect.
want to file an affidavit, don't file an affidavit.
No. This
But
affidavit.
if you are saying it's as per the
Yes.
order of this court,
As per the order of this honorable court
directed me
dated
to file
30.
affidavit. We did not direct you to file any affidavit.
Yes, there is a direction to file affidavit. My lord.
He recorded your submission that you will be filing.
Yes, my lord, but there is a
Because you
direction.
wanted the matter to be disposed of, saying that you won't claim any equities.
Ultimately, my lord, the affidavit is in between I and government employee, my lord. That is,
Firstly, it is not a direction of the court.
yes, my lord. This is a direction which your lordship has given. Anyhow, my lord, if your lordship is not satisfied, my lord, then I will file better affidavit.
Satisfied. You want to file it, you can file it. If you don't want to file it, don't file it.
No, there is a direction, my lord. The Shetty is so and so is directed to file affidavit of the respondent number 3. So that, my lord, patently I have filed, my lord.
Read para 13.
Yes, my lord. Having regard to the submission made by the learned counsel appearing for the appellants and respondent number 3, I am of the considered view that appellants having already suffered by the judgment of dismissal, the interest of the appellants would be safeguarded by recording the submission of the respondent number 3. That respondent number 3 would not claim any equities in the construction being put up, and that if the appellants were to succeed in these proceedings, respondent number 3 would hand over the construction without any encumbrance to the appellants.
In there, you see your submission, para 12. Para 12, page 6. Last line of that para.
Yes, my lord.
That is the submission which is recorded.
Since the respondent number 3 municipal authority, learned council appearing for the respondent number 3 seeks a week's time to file affidavit of the chief of the municipality, Chandrapatana, so and so. The lordship, before that, my lord. Yes, my lord. Paragraph number 12, my lord, your lordship may kindly peruse. Towards the so and so learned council appearing for the respondent number 3 submits that respondent number 3 is a municipal authority which is implementing the project of smart city, and for this purpose the construction which is being put up is that of it, and for the purpose the construction shopping complex for which the funds have been received from the central government. He submits that at present only construction being taken up. Some more time is required to complete the construction, and thereafter the said construction is only proposed to be leased, and respondent number 3 does not intended to alienate or transfer the property or any portion thereof by way of sale. He further submits that any delay caused in construction of the same would result in escalation of the project cost, and public funds would be unnecessarily be wasted by such escalation. He submits that respondent number 3 may be permitted to go ahead with the construction, and respondent number 3 would not claim any equity in the event of the appellant succeeded in the present appeal. So that, my lord, I have filed affidavit saying that.
Saying what?
Saying that, my lord, your lordship may kindly come to paragraph number 3, my lord. I state that as per the order of this honorable court, the order dated 13/1/2022, so and so directed me to file affidavit for not to claim any equities in the construction being put up at a municipality land. Accordingly, I am filing this affidavit to the above effect for obeying the direction.
Did we direct?
My lord,
Did we direct?
to file affidavit.
You took time to file an affidavit.
Yes, my lord. Because of the very same day, I don't have affidavit, my lord. Because after
it was not a direction; it was your submission. Otherwise, we would have gone ahead with the matter.
No. While my lord, oral discussion was taken place, my lord, your lordship has please file the affidavit. I said, my lord, I will file affidavit. Now I have filed affidavit.
Affidavit is also not as per what your submissions are.
Your lordship is not satisfied, then I will definitely file better affidavit.
Please file a better affidavit and go.
Please. Yes.
If you want to
Ultimately,
file
my lord,
you could file. Otherwise, you want it to be taken up on merits, we can take it up.
No, my lord. If it is in the appellate stage, my lord, it's a RFA first appellate proceedings before my lord. If it is a writ jurisdiction, my lord, of course, my lord, filing the affidavit that this, my lord, it is necessary. It is, my lord, first appellate proceedings is going before my lord. So that, my lord, I thought it is a direction I have to obey, because they defeated, my lord, before the learner trial court. Accordingly, my lord, they have preferred, my lord, appeal before this honorable court. My lord, any date, my lord, 1 or 2 weeks, my lord. And my lord, it may be, my lord, released from part heard, my lord. It is part heard matter, 2021 matter, my lord, RFA.
Lord, my humble submission is.
Both of you requested it to be treated as part heard.
Allah, avatu, by lordship justice.
That I am ready to make my submission on IA number 2 regarding not to put up the construction. If there is a specific order which may be passed by this honorable court, directing the respondent number 3 not to encumber the proper, not to create any encumbrance, or that they would not claim any equity with respect to the proposed construction after if the appellant succeed, I would be much obliged.
That is what the submission
Direction
was.
may be passed regarding.
Let him file the affidavit. Sri Pavanchana Shetty, learned counsel for Theatre respondent number 3 seeks for a short accommodation to file a better affidavit in terms of the submissions made by him on.
Kindly refer to para 4 of their affidavit. They say that the content of para 1 to 3 of the caveat petition accompanying this affidavit are true and correct.
13/1/2022. Relist on 7/3/2022. If it doesn't come, then we'll deal with it.
My lord, with respect to office objection number 3, I've already served the government counsel, and office objection number 3 is.
Yes, madam.
Affidavit of service.
Give one more copy. What
my lord, appeal memo not served, my lord. Only particular
we have filed.
Please, my lord. This
He
is my
has
copy.
received the entire copy, my lord.
Madam, you want it to be heard. It's
No,
your
my lord, we
opinion.
have
Memo is
served
not given, my lord.
through
Do you have an
RBAD, through
acknowledgement?
RBAD,
Why do you
since
serve
there was a caveat petition on December itself, I have served the entire copy. Nonetheless, I will furnish a fresh set. Please, ma'am. Please.
That last line should have been your first submission. Why all this?
Please, my lord. My lord, office.
Between councils don't have all these things. One copy,
Please, I
furnish
will
one
furnish
copy.
fresh copy, my lord.
Nothing happens in giving one more
Affidavit of
copy.
service has been filed with respect to government service on the government.
You want to stick to that or you want to give a copy?
No.
When this also accepts notice for respond number 1 and 2, registry is directed to print her name as that appearing for respond number 1 and 2.
Oblige.
Petitioner in this case. It's
What is
respondent
it?
number 3 is the legal representative of respondent number 1 and 2. I have filed a memo to that effect. And I also placed the order that has been passed by the trial court.
No, just one minute. It's come up now for non-filing of application and copy of the order trial court in 17-122 order.
Yes, I have filed it.
File ಮಾಡಿದ್ದೀರಾ?
Madi.
ಯಾವ್ದು ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
It's on 19th.
19?
19th.
ಏನು ಇಲ್ಲ ಇಲ್ಲ. First time petition ಇದೆ. Learned counsel for the petitioner submit that he has filed copy of the application and order of the trial court.
I have filed the memo.
Along with the memo on
19th of February.
19/2/2022. Registry is directed to put up the same. 19/2 ಅಂದ್ರೆ Saturday ಅದಕ್ಕೆ. ಏನು ಬರುತ್ತೆ? You took 1 month to file. So give the office 3-4 days for it to be list on 8/3.
Matter may called along with your petition number 1.
We'll call it along with it. Why haven't you taken steps?
Lordship, in trial court, they have brought the LRs of the respondent on record. Their Lordship, we have contended that they are not LRs. So we have filed, Lordship, the trial court has allowed the application. Now we have filed the petition telling that order.
No inquiry under 22 rule 5. ಯಾವ ನಂಬರ್ ಏನದು?
1936 of 21.
Right, counsel for the petition submit that the above matter is connected with so and so. Registry is directed to connect the same and relist on 10th.
Respondent number 5 is third copy on respondent number 5 by way of email.
You received?
Yes, my lord. They have served a copy on us by email. And I was informed by my lord that they will be serving us a hard copy today. So therefore, I request them to file a hard copy to me, my lord. In fact, on Friday, my lord, when I called them, they themselves told that I will be serving before the court. I told them I'll endorse and give it.
There was specific order, Lordship. If you are not going to serve, it will be dismissed within 2 days.
My lord,
So I wanted to serve it before court.
all accepted, my lord. In fact, on Friday,
Today,
my
no,
lordships are not
Lordship, on that day, Lordship was on video conference. Was not physically available here.
I agree, my lord, but on Friday, my learned
So
was
Lordship,
here in
on
court.
that same day, I have served the copy on
You furnish that. You said today you'll give the hard copy.
Yes,
Give
Lord.
one hard copy.
But
ಯಾಕೆ
Lordship,
ಅದಕ್ಕೆ ಇಷ್ಟು
I
litigation?
agree to the fact that they
ಇನ್ನ
served me.
ಕೇಸ್ಗೆ ಬಂದಿಲ್ಲ, ಬರೀ ಕಾಪಿ ಮೇಲೆ litigation ಆಗ್ತಾ ಇದೆಯಲ್ಲ ಇವತ್ತು.
All I require is a hard copy so that I can file complaints. Submitted the
putting more blame on me, Lord. That is why I'm making.
No, my lord, I agree to the fact that they have served me an email on the very same day on the last hearing. I am not denying that at all. All I
Counsel,
seek is a hard copy.
now the proceedings are being live streamed. This is the kind of
I'll serve, my Lord.
submissions which are going to be made. It doesn't reflect good for you. ಅಷ್ಟು ಕೊಡೋಕೆ ಏನಪ್ಪ? ಅಲ್ಲ ಅಷ್ಟೇ ಕೊಡ್ತಾ ಇದೀನಿ ಅಂತ ಕೊಡ್ಬೇಕು.
ಅವತ್ತೇ ರೆಡಿ ಇದ್ದು ಸ್ವಾಮಿ ಅವರು
ಅವತ್ತಲ್ಲ ಇವತ್ತು ಕೊಡ್ಬೇಕು.
ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಅಲ್ಲಿ ಇದ್ದ ಕಾರಣ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗಿಲ್ಲ.
Another additional submission. My friend on 23rd mentioned that they will be serving certain citation memos.
That also.
Let that also be served to soft copy. I have no problem with that, my lord, but let that be served so that I can make my arguments and everything.
Grand counsel for the petitioner has served a copy of the writ petition along with annexure, which is received by the counsel for respondent number 5. Grand counsel for the petitioner seeks for a week's time to produce certain citations that he intends to rely upon while arguing in the above matter, after furnishing a copy thereof to the counsel for the respondent. Relist on 10/3. For a writ petition, why do you want to file objection?
We'll serve them in advance and we'll argue.
For a writ petition, you don't need to file objection. You address your arguments.
P3 ಡೆತ್ ಆಗಿದೆ ಅದಕ್ಕೆ ಎಲ್ಲರ
P3 death, yeah.
ನಂಬರ್ 3
R2 abated, huh? When did P3 die?
13/5/2021.
13/5. ನೀವು application ಹಾಕಿದ್ದು
7/2/22.
7/2?
7/2/20.
17/2.
17/2. Sorry.
ಅಬೇಟ್ಮೆಂಟ್ ಕಂಡನೇಷನ್ ಏನು ಕೇಳಿಲ್ಲ.
ಅದರಲ್ಲಿ ಮೆಮೊದಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಮೆಮೋ ಅಲ್ಲಪ್ಪ, ಅಪ್ಲಿಕೇಶನ್ ಹೇಳಬೇಕು. ಒಂದೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಸಾಕು. ಬಟ್ ಯು ಹ್ಯಾವ್ ಟು ಆಸ್ಕ್ ಫಾರ್ ಕಂಡನೇಷನ್ ಡಿಲೇ. ಎಷ್ಟು ಡಿಲೇ ಇದೆ? 1 year ಇದೆ. ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡಿದ್ರೆ ಹಿಂಗ್ ಮಾಡೋದು. Counsel for the petitioner seeks for a week's time to file necessary application for condemnation of delay in bringing the legal representative of deceased petition number 3 on record. ಯಾವತ್ತು ಹಾಕ್ತೀರಾ? Relist on 10/3. Oh, interim order earlier granted is extended till next day.
I appear for the petitioner in this matter, my lords. We have filed a memo of retirement. We are unable to communicate with the petitioner.
You are unable to communicate.
I mean, we are not able. The number which was given is not going through, and there has been no communication from their side. We had challenged an order where
Where is the acknowledgement card, madam, for your notice?
The acknowledgement has not yet come to us, but we checked online and it has been served.
Then you should produce that.
I will produce it.
Notice is not
2 days ago it shows as received. I will produce that, my lord.
Learned counsel for the petitioner seeks for a week's time to produce the acknowledgement or postal track report of service of notice produced along with the memo of retirement. Relist on 11/3. So Sangvi, please unmute yourself. You're on mute, Mr. Sangvi. Unmute ಮಾಡ್ಕೊಳ್ಳಿ.
Your lordship may kindly grant 2 weeks time. My elder brother expired last week. Couldn't comply with the objection.
2 weeks time.
2 weeks time. Earlier.
2 weeks, Mr. Sangvi.
2 weeks. 2 weeks.
Seeks for 2 weeks time to comply with office objection. We list on 15/3. What is this recalling, Mr. Vishankar? ಏನ್ ಮಾಡ್ಲಿಲ್ಲ ನೀವು?
Was filed long ago on 16/1.
So you are not present in court.
ಹೌದು.
ಬೇರೆ ಏನು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಏನಿಲ್ಲ?
ಇಲ್ಲ.
ಎಸ್ ಮೇಡಮ್. ನೀವು
ಗವರ್ಮೆಂಟ್ ನವರು ಪಾರ್ಟಿ ಇದ್ದೀರಿ.
ಹಲೋ ಮಾಡದ
ರೀಕಾಲಿಂಗ್ ಹಾಕಿದ್ದೀನಿ. ಡಿಸ್ಮಿಸ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್.
After the discussion.
Exemplary cost, Vedva. Then what is the matter about?
The matter is about the impounding of the document. The suit for injunction. Ready na anta keltani. Last may allow the application and post.
ಇವತ್ತೆಲ್ಲ ಯಾರ್ದು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಇವತ್ತು. Accepting the reasons stated in support of IA1 of 2019. The same is allowed. The order dated 17/12/2018 is recalled. The writ petition is restored to file, subject to payment of a sum of ₹500 as cost.
There was no delay at all.
It shall be paid to the advocates, library fund, library fund. Within 15 days from today, pre-list on 15/3. And counsel for the petitioner is also directed to furnish a copy of the petition and annexes to the learned AGA.
Lord, I appear for the respondent, Lord.
Yes, Mr. Agre.
Lord, certain documents have been filed, my Lord, along with an application, Lord. I need to take instructions. These documents, my Lord, are even subsequent to the impugned order passed in MA. Lord, I need to take instructions, my Lord. Kindly grant me 2 weeks time, Lord.
Mr. Ariga.
In fact, it was argued in B group, Lord, and it was found that the plaint, written statement, IA and counter all are not filed and in the compilation. Time was granted to file the.
Vishwanath Hegde, learned counsel for the caveator respondent, seeks for 2 weeks time to file his objections to IA1 of 2022. Re-list on 21/3. Yes.
Getting strength. We'll argue merits. Not so. Suit for partition was filed. Suit for declaration was filed.
Declaration and partition.
Declaration was filed. Containing Millards that as per Palapatti dated 17/8/1983, suit properties were allotted to the share of the contesting respondent who was a plaintiff in the. I should say this, my lords, I am a defendant in the trial court, and plaintiff and the defendants are brothers. Plaintiff is the elder brother and defendant is the younger brother. The contention of my lords, the plaintiff is that at Palapatti dated 17/8/1983, there was a partition. And in the said partition, suit properties were allotted to his share. And later on, please, Your Honor, my lords, there was yet another second Palapatti, Panchayati Parikattu. That is dated 1/1/1985. There were some changes in the family. They opted for a second Panchayati Parikattu. At the said second Panchayati Parikattu, suit properties were allotted to the share of the defendant, that is the younger brother, and certain other properties came to the share of the elder brother, who is a plaintiff of the court below. Now the contention, my lords, is that plaintiff denied execution of second Panchayati Parikattu, 1/1/1985. The signature of plaintiff in the first Panchayati Parikattu is in English. Whereas in second Panchayati Parikattu, it is in Kannada. My lords, before the trial court, we produced documents for the court below. Plaintiff is a government servant and he was working and he retired as a government servant also. Please. Yes. Exhibits D16, D17, D18, D75 and D76 were produced before the court below in the evidence of defendant. Some of these documents were registered documents, which were executed much prior to, please, lords, second Panchayati Parikatu dated 1/1/1985. In these documents, the plaintiff had signed in Kannada. It is only in the year 1983 when first Panchayati Parikatu got executed. The signature is in English. Now the question is, my lords, the trial court, without making proper observations, lords, even documents were also not appropriately appreciated. Suit came to be decreed. And in the appeal, my lords, now a request is made by the defendant who is the appellant before the regular in the first appeal. An application is filed under Order 26 Rule 9 CPC, requesting the court to send it to handwriting expert for an opinion.
Rule 9. 9 or 10?
26. 10. Sorry.
Yes.
The first appellate court would say in the order, no doubt there is a power for the first appellate court to send it to scientific examination or rather comparison opinion by the handwriting expert. But there is a delay in filing the application. That is what the trial first appellate court would opine for the purpose of dismissal of the application made by the appellant, rather was a writ petitioner before my lords.
Yes.
My lords, in my humble submission, my lords, these documents apparently suit being one for declaration of title, and there is a mischief on the part of plaintiff, who was a government servant and a responsible officer then, and he has used this trick in sort of signing the document in English in one document and in another document in Kannada. If these documents are sent, my lords, it would meet the ends of justice. And my lords, even the first appellate court admits it is definitely permissible for the appellate court to exercise jurisdiction for the purpose of
That document was marked in evidence in the trial court.
It was marked in evidence.
You cross-examined him.
Please, my lords.
What are the cross-examination?
Cross-examination. Execution of that document which is in Kannada was not denied. That document, please, my lord, that which exhibit D16, 17, 78, 71, which was in Kannada, that is deposit of title deeds, which plaintiff had executed in Kannada. He had not denied that document. Now the question is, please, my lords, the signature which is found on the Panchayati Parikatu.
Mr. Rashekar, this is an application that you filed in the first appeal. This is not in the original proceedings.
I understand.
So the
now
consideration of the application will be on a different footing.
Please,
but filed it in the original proceedings.
I can't, my lords, ask.
Now, when you are put on notice for the production of this document, the marking of this document, if you had any, what is the reason for not having sought for this earlier and now at the first appellate court?
My lords, I only humble submission would be the trial court when looking into the signature. May I invite my lord's kind attention to the trial, judgment passed by the trial court.
Page number? Para? 9. The 9 I heard the argument. The first question, additional issue is whether defendant number 1 proves a due and valid execution Parikat Schedule 185. The issue which has been framed.
Can we come to page number 108, lords?
Yes.
It is the argument of the learned counsel for the defendant number 1 that the disputed signature of the plaintiff found in exhibit D1 and the admitted signature of plaintiff in exhibit D17, which is the registered document, are one and the same, and hence the due and valid execution of exhibit D3 is to be presumed. On perusal of the exhibit D3 and exhibit D17, the signatures found appear to be one and the same. But on careful examination of both the signatures, it gets clear that in exhibit D17, the character found in signature is shown, a replica is shown, which differs from the character found in signature so and so in Exhibit D3, in Exhibit D17 so and so. The character found in the signature, that is the word Gauda, which differs from the character found in the signature in Exhibit D3. Under the circumstances, the signatures found in Exhibit D3 and Exhibit D17 cannot be considered to be of the plaintiff. This exercise is under Section 73 of the Evidence Act, not by the trial court. But in my humble submission, Lord, I understand I am before the appellate court, but notwithstanding, in the ends of justice, my lord, these definitely will be in the domain of the handwriting expert.
Yes, Mr. Gowda, how could the judge on an ocular basis decide whether the signatures are his or not? If there's a dispute like this.
May I make one submission?
Yes.
That plaintiff and defendant, they are brothers. And according to it's an admitted fact that in the year 17/8/1983, there was a partition between them. In the said partition, 15 items of the property has been given to the defendant.
We were not on merits.
One minute, only for this consideration.
But
one 15 items, measuring 10 acres, 15 guntas has been allotted. And only 5 acres that has been allotted to this plaintiff. Again, the second Panchayat Parkat, what my learned friend is relying upon, it is with respect to my properties, which were allotted in the first property. He has created a document and including the property which I purchased in the year 1986 under a registered sale, including my property, a second partition, not with respect to all the properties. So far as the allotment of 10 acres, 15 guntas, what it was allotted to him, that he has retained and it is kept to his property. So far as my property, whatever it is allotted under 1983 partition, again me created a partition deed on a plain paper, not even a stamp paper or any such thing. And he created whatever the properties that has been allotted under the said partition is to his share. And property what I purchased in the year 1986, subsequent to 1985, that is allotted to me in the said partition.
Yes.
That is the stand what he has taken. My lordships, dear lordships, aware that so far as the conduct of the party hearing, that a open challenge that has been made at the time of cross-examination, that the document could be referred to a 4 and 6 zones. That he has not referred the document before the trial court, and he kept quiet and relied upon the registered documents. When the court gave findings against him, after 4 years after filing of the appeal, he filed this appeal. And he wanted to refer this documents to the forensic. Let the trial court,
Evidence Act. Yes.
9 of the impugned order. May I request your lordships. As such, the plaintiff respondent has thrown an open challenge to send the disputed documents for a handwriting expert. Despite this, appellant defendant has simply kept quiet. On the contrary, he has produced some loan records as per Exhibit D16 to D18, 75, 76. But now has come up with the application seeking an order to send the disputed document on the registered partition deed as per Exhibit D3 along with the above said loan documents as per Exhibit so and so handwriting expert, with a direction to compare the signatures found thereon with the signature of the plaintiff respondent, now taken before court. But as stated above, the cross-examination of PW1 clearly demonstrates that though the plaintiff has preferred to go for the opinion of the handwriting expert at the earliest, the appellant defendant has kept quiet till now. Since Exhibit D3 was produced by the appellant himself, the burden of proving the same was upon the appellant only. But the appellant has not discharged his burden in a proper way before the court below at the first instance. But now he has come up with this application alleging that though he had informed his counsel, he relied upon only upon a registered document as per Exhibit D17, but no affidavit or a memorandum of facts is not filed by his counsel before the court below to substantiate the same. Hence, his board allegation to the effect that he had informed his counsel to cannot be accepted at this stage. The findings recorded by the trial judge are based upon the evidence placed before him. During the trial, both the parties accordingly has refused to believe and act upon the above said memorandum of partition dated so and so, on the ground that the admitted signatures and disputed signatures differ from each other. So, as such, obviously, now the appellant defendant has come up with this application so and so. May I request you to next page, page 8. The third line, third, fourth line. But the facts and materials recorded on and clearly demonstrates that the appellant defendant was well aware of the dispute raised by the plaintiff regarding his signature on the disputed document, the unregistered memorandum of partition, dated 1/1/1985. Despite this, when he has kept quiet for such a long time, now it is not proper on the part of the appellant to come up with such an highly high-belated application. In my opinion, under the above facts and circumstances, I am of the opinion that principles involved in this case, so and so not applicable, so and so. But with these observations, let the application what the has been rejected. And even let that apart, a larger question for legal question consideration of this honorable court is that the document which my learned friend is relying upon is an unregistered, and it is a document made on a plain paper. And as your lordships aware that as per the stamp duty, stamp act under section 34, any document which is not properly stamped or insufficiently stamped cannot be relied upon for any of the purposes.
It is already marked, D3
Even if it is marked, marking is a ministerial act, and the admissibility of the document in evidence, that has to be applied.
Was it kept open?
Yes.
Was
yes.
that issue kept open of admissibility?
Let
Subject to objection mark aita.
Even with consent, the document is marked. That also cannot be considered as per the law declared by the Honorable Supreme Court and as per the section 34 of the Stamp Act.
One indulgence. Both the partition deeds were on paper. Adunu madalnedu kuda em stamp paper illilla.
So audition.
Madalne stamp paper.
Audition. Mark ಆದ್ಮೇಲೆ ರಿಲೈ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತನಾ? Impounding of the document, Mr. Gowda.
Para 22 onwards. Para 22.
Citation.
2000. Third. Para 22.
Yes, sir.
Section 35 of the Act rules out admissibility of such a provision as it is categorically provided therein that a document of this nature shall not be admitted for any purposes whatsoever. If all purpose for which the document is sought to be brought in evidence are excluded, we fail to see the reason as to how the documents would be admissible for collateral purposes. The view we have taken finds support so and so, so and so. The words for any purpose in section 35 of the Act, Stamp Act, should be given. This is with reference to Central Act, section 35. Our Act, it is section 34. Stamp Act should be given their natural meaning and effect and would include a collateral purpose, and that unstamped partition deed cannot be used to corroborate the oral evidence for the purpose of determining even the factum of partition.
The facts,
as distinct.
Mr. Gowda, facts are different. In that situation, the document was sought to be marked in evidence. At that stage, it was impounded. In your this one, it has already been marked in evidence. After marking, without any objection, can you say that it cannot be relied upon?
My submission is that even if it is marked with consent, the section is very clear. Section 34 of the Stamp Act.
There's a catena of decisions which say that once it is marked, you cannot raise this objection.
ಅಲ್ಲ ಅದು milord, if it is marked, milord, if the document is sufficiently stamped and if it is impounded for payment of proper court fee. Here section 34 you last kindly see.
Karnataka stamp.
Karnataka.
Yes. Shall be admitted in evidence.
Yes. 34.
After admittal in evidence, what happens?
ಅಲ್ಲ ಇದು section 34 first ಗೆ instrument not duly stamped, inadmissible in evidence, etc. No instrument chargeable with the duty shall be admitted in evidence for any purposes by any person having by law or consent of a party's authority to receive the evidence or shall be acted upon, registered or authenticated by any such person or by any public officer unless the instrument is duly stamped. Here, Your Lordship, kindly I request Your Lordships to consider the wordings. A purpose by any person having by
There are
law
enough and more decisions which this provision has been interpreted.
the Supreme Court. That's why, my lord,
That is not, that's a case where at the time of marking it was impounded. Please show us a decision where after marking it cannot be relied upon.
even my lord, that's why, my lord, here the document.
Anyway,
which,
that is beside the case because that is not the issue involved in this matter. Issue involved here is 26 rule 10, not section 34.
my lord,
26 rule 10 illi iradu, 34 illa illi, issue illa illi.
ಅಲ್ಲ 34 ಯಾಕೆ ಇಶ್ಯೂ ಬರುತ್ತೆ ಅಂದ್ರೆ when the document itself is, my lord, not receivable in evidence and, my lord, it is not admissible in evidence and there is a clear bar under section 34 and, my lord, the very, my lord, referring of the document and, my lord, proving of the document for partition would not arise for consideration. My submission is even for the arguments, my lord, so far as, my lord, my lords have put one question to me, my lord, that, my lord, whether after marking of the document is there any judgment to the effect that has to be, my lord, whether to be considered or not to consider.
According
Even
to
on
us,
that also there is a judgment. Last may kindly have it tomorrow, my lord, day after tomorrow I will produce them. Day after tomorrow. ಅದು ಇದೆ ಸ್ವಾಮಿ, ಅದು citation ಇದೆ.
Anyway, that is not relevant 34. 26 rule 10 ಹೇಳಿ.
ಅಲ್ಲ ಇದು 2015 part 3 KCCR 2607 ಬಂದಿದೆ ಅದ್ರದ್ದು. ನಾಳೆ ನಾಡಿದ್ದು ಇಟ್ಕೊಳ್ಳಿ ಸರ್, ನಾನು ಕೊಡ್ತೇನೆ.
After arguing for some time, Sri Gowda Learned Counsel
One
for
submission.
respondent seeks for a day's accommodation. Released day after tomorrow. Heard in
Yes.
part. Mr. Raghupati,
He appeared for the petitioner.
Ms. Nagashri, who appears for the respondent?
Nagashri appears. There is an interim order of stay throughout. But still they are changing the nature of the property. Injunction itself is for not to change the nature of the property.
Interim order ಇದ್ರೆ ಇವಾಗ ಏನ್ ಮಾಡಬೇಕು?
ಅದಕ್ಕೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ಬಿಟ್ಟು ನಾನು ಇನ್ನೊಂದು ಇಂಜಂಕ್ಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ.
Injunction contempt ಹಾಕಿ Mr. Raghupati. If they are violating the orders of the court, we will take action against them. ಇದು ಹಾಕಿದ್ರೆ ಮತ್ತೆ ಇದಕ್ಕೂ ವೈಲೇಷನ್ ಆಗುತ್ತೆ.
Next week ಹಾಕಿ.
There are no regard for the order, then action will have to be taken. Please establish it.
Please.
The counsel for the petitioner is present, but none appears for respond number 1 to 7. Shri T.N. Raghupati, learned counsel for the petitioner, seeks for a week's time to file a certain application. Released on 8/3/8. Yes, Mr. Ashok.
I appear for the petitioner, Lord. Serial number 12, I appear for the petitioner. I filed this application to bring the LRs of the deceased respondent, Lord. Notice may kindly be ordered.
Respondent is dead.
Respondent is dead and filed 4 LRs are there, Lord. Proposed LRs. kindly order notice order for the issue of.
ಒಂದೇ ಐಎಲ್ ಎಲ್ಲಾ ಪ್ರೇಯರ್ಸ್ ಕೇಳಿದ್ದೀರಾ?
ಅಲ್ಲ ಅಲ್ಲಿ ಒಂದೇ ಪ್ರೇಯರ್ ಕೇಳಿದೀನಿ. ಪ್ರೇಯರ್ ಒಂದೇ ಐಎ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಐ sought for a bring the alarms of the respondent ಅಂತ ಹೇಳಿದೀನಿ.
When did they expire?
I have not date of death is not 5/5/2021.
You filed this application on 27/1/22, Mr. Bhatt.
Please, my lord, I filed after about 10 months.
You're not asked for setting aside abatement or condemnation.
I'm not sought for that. I'll file a necessary application if it is your lordship feels so. I filed one application.
ಎಲ್ಲ ಕೇಳಬಹುದು.
Please.
ಇಲ್ಲ 3 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಬಹುದು. ಬಟ್ ಕೇಳಬೇಕು. ಕೇಳಿಲ್ಲ ಅಂದ್ರೆ ಕೊಡಲ್ಲ.
I'll file a fresh application.
ನೀವೇನಿಲ್ಲ ಇವಾಗ ಫಂಕ್ಷನ್ ಸಫಿಷಿಯಂಟ್. You can't, your wakalat is gone. You're not entitled for anything unless you are going to represent the legal representative. ಅಪಿಯರ್ ಆಗ್ತೀರಾ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಗೆ? ನೀವು ಅಪಿಯರ್ ಆದ್ರೆ ಅಂಡರ್ಟೇಕ್ಸ್ ನೋಟಿಸ್ ಅಂತ ಇಲ್ಲೇ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬಿಡೋಣ. ನೋಟಿಸ್ ಹೋಗೋದು ಬೇಕಾಗಿಲ್ಲ. Shri S.N. Bhatt seeks for a short accommodation to file necessary application for condemnation of delay and setting aside abatement. Relist on.
There is a specific direction to deposit that and 50% is
ಅದು ನಿಮ್ಗೆ ಎಂಟೈಟಲ್ಮೆಂಟ್ ಬರಲ್ಲ. 9(3) ನೀವು ಅಪಿಯರ್ ಆಗ್ಬಿಟ್ಟು ಹೇಳ್ಬೋದು.
Interim order may kindly be extended.
Interim order earlier granted is extended.
it is expired already. Interim order is already granted expired.
One minute, Mr. Bhatt.
Last time it was extended. In the last hearing date, it was extended.
Because 4 weeks.
Extended again.
Last hearing date, it was extended.
Mr. Javed.
Appearing for the petitioner, my lord.
Yes.
Petitioner has expired on 6th May
Sole
2021, my lord. Sole petitioner, my lord. Please, my lord. Sole petitioner, my lord.
During the pendency of the above matter, the sole petitioner expired on
6/5/2021, my lord.
6/5/2021. Pursuant thereto.
Application filed on 11/2/2021.
1 of 22, 2 of 22, and 3 of 22 have been filed to bring the legal representatives of the to condone the delay in filing the application for bringing legal for setting aside the abatement, application to set aside abatement, and an application to bring the legal representative deceased petitioner on record. Accepting the reasons stated in IA 1 of 2022, the delay of 131 days in filing the application is condoned. Consequently, the abatement is set aside, and IA 3 of 2022 is allowed. The persons named in the said application are brought on record as legal representative of deceased petitioner. Counsel for the petitioner is directed to carry out necessary amendment to the petition and file amended petition copy after service on the counsel for the respondents.
Please, my lord.
Respondents. Relist on 22(3).
Obliged, my lord.
Respondents 3 to 5, 17 to 19.
Are 22, 23, and 24. My learned friend has not produced the RFA judgment passed by the Honorable Court in RFA 1479 of 2012, my lord.
The first not furnishing of DPF for issuance of notice to R7, 16, and 20.
Already paid, my lord.
When did you pay it?
17. And also having the acknowledgement.
What the acknowledgement? Acknowledgement. Online pay madra, physical payment madra.
Counter pay. What are the process detailed? All those acknowledgements are there. The last one is the
17 to
acknowledgement for having paid that.
Shri Mohammed Nasiruddin, learned counsel for the petitioner, submits that an amount of ₹350 has been paid as process fee on 17/2/2020. Registry to verify And if the said amount has been paid, issue notice to respond number 7, 16, and 20. Returnable by
No, one more submission, my lord.
20th April.
May I make one submission? my lord?
ಒಂದ್ ನಿಮಿಷ ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಕ್ ಮುಂಚೆ ಇಷ್ಟೊಂದು ಲಿಸ್ಟ್ ಇದೆ ಒಂದೊಂದೇ ನೋಡೋಣ. Rectification of office objection raised on amended WP.
That was also filed, my lord.
What is your objection? What is the objection?
That was also filed.
What is the objection, Mr. Nasir?
The objection, my lord, your lordship.
P1 dead and P2 to 7 are treated as legal is not shown in the amended cost title.
With clear acknowledgement, we already filed amended and also we filed memo.
Mr. Nasiruddin, please listen to the question. It's been returned with office objection. I'll ಓದಿ ಅಲ್ಲಿ. ಮತ್ತೆ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಇದೆ ತಾನೆ?
ಅದು ಹಾಕಿದ್ಮೇಲೆ ಏನಾಯ್ತು ಅವ್ರು ಆಮೇಲೆ they are returned. And your lordship, this was done on 17 February. And the matter was listed on Friday. We were here till 5 o'clock. But unfortunately, my lord is in the division bench. We could not able to. Thereby the list was again repeated. My only submission to my lord is when the matter came up before my lord on 24/1/2020, 24/1/2022, my lord. I was not in station. My colleagues represented before the court through video conference. And my lord was pleased to vacate the order of interior, which was granted on and for having not paid the process fee, my lord. Your lordship kindly see, my lord, on 28th, the order is on 23rd. We paid on 28th December itself. There is an acknowledgement, 1,200 rupees to pay the process.
ಯಾವತ್ತು?
Your lordship on 24/1/2022, my lord.
22 ಅಲ್ಲ Mr. Nasiruddin. The order that is speaking of.
Order 24/1/2020. Come order. Your lordship, last 3 lines kindly see, my lord. In view of the conditional order dated 23/12/2020, the interim order lapsed on 30/12/2020 on account of steps not having been taken. My lord, 28th itself we have taken the process.
28th of
2020. This is within 5 days.
ಎಲ್ಲಿದೆ ಅದು?
Within 5 days we paid. The only mistake is we on that day, my lord, my colleagues represented through video conference, they could not able to show before the court.
ಯಾಕೆ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಬಂದಿಲ್ಲ ಇದು? Shri Mohammed Nasiruddin, learned counsel for the petitioner, submit that the petitioner on 28/12/2020 had made payment of a process fee of rupees 500 in compliance with the order dated 23/12/2020. He submitted that unfortunately the same could not be brought to the notice of this court on the last date of hearing. A parallel of the order sheet indicates that note sheet indicates that there is no reference to the same made by the office. The Registrar Judicial is directed to look into the matter and ascertain as to why an endorsement to this effect has not been found in the note sheet, which has resulted in the vacation of the interim order by this court's order dated 24/1/2022, holding that there is no compliance with the conditional order dated 23/12/2020. now that it's been pointed out that the process fee had been paid on 28/12/2020, the interim order. But even that, Mr. Now will it help you? Continue.
Dated 21/12/2020.
ಯಾವತ್ತವರೆಗೂ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ ಅಂತಾನು ಇಲ್ಲ ಅಲ್ಲಿ.
Till next date of hearing ಅಂತ 21/12/2020.
Stands extended. ಆಯ್ತು, ಇವಾಗ ನೆಕ್ಸ್ಟ್ ನಿಮ್ದ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ನಿಮ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇತ್ತು, ನಮ್ಗೆ ಬಾಕಿ ಎಲ್ಲ ಇಂಟ್ರೆಸ್ಟ್ ಇದೆ. ರೆಕ್ಟಿಫಿಕೇಶನ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
No, that was done.
ಯಾವತ್ತು ಮಾಡಿದ್ರಿ? What is the office objection and what have you done with it?
And so far as the IA2 is concerned, my lord, that here dispensation, that may be dismissed.
You want to say whatever you want to say. We are asking you in line of what is there in the cause list. Item number 2, cause list idya ನಿಮ್ಮ ಹತ್ರ?
Tomorrow will.
Cause list idya ನಿಮ್ಮ ಹತ್ರ? Do you have the cause list with you? Then you are making submission without having a cause list.
Writ petition for petitioner P2 to P7 treated as LR's deceased P1 not shown. Because the P7, my lord, they already, her LRs already are record.
Where is it shown, Mr. Nasruddin? You should ascertain all the cause list is printed earlier.
Your lordship, with great respect, I'm sorry, my lord. The first petitioner who is before my lord is the mother of petitioners 2 to 7. She already
The question is very simple, Mr. Nasruddin.
No, that has to be carried out.
Office has raised objection.
That has to be carried out.
You submitted that it's been done.
No,
So we are asking you when.
That tomorrow I will carry out.
ಇನ್ನ ಮಾಡಬೇಕು.
ಅಲ್ಲ ಅಷ್ಟೇ ಅದು ಒಂದೇ ಮಾಡಬೇಕು. So far as the IA2 is concerned, for dispensation, we already filed the certified copy of the final decree.
Mr. Nasruddin,
Thereby that may be dismissed.
if this is the way you are going to be submitting, it becomes difficult to run the matter. Please see the number. There are 5 items.
Yes, my lord.
ನಿಮ್ಗೆ ಏನ್ ಬೇಕು ಅದ್ ಮಾತ್ರ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. 5 items ನೀವ್ ಹೇಳ್ಬೇಕು. Item number 2, you said you will do it. Item number 3, you have 5 objections which you have kept.
Yes.
What about third objection?
But tomorrow it will be done. Even the amended petition also we filed.
We'll consider and dispose of the matter also. Having all these things, we have to consider these issues. We are not getting any assistance from Mr. Nasruddin ashte.
Your lordship, my only submission to my lord is.
Nimma
So far
submission
as-
ಆಮೇಲೆ ಬರೋಣ.
First objection is 2 to 7 ಅಂತ. For that also we filed memo, my lord, before the court on 17th. What we have stated, the petitioner has actually submit that after filing the present petition, respondent number 2, that is Hasina Begum, and respondent number 7, Sirajul, has passed away. However, it is submitted that respective legal heirs are already on record as the respondent 3, 4 and 5 for respondent number 2 and the respondent 18 and 19 for respondent 17 respectively.
When did you file?
This memo we filed on 17th February. 17th February.
A copy has not been furnished to us.
On 17th itself.
What does that have to do with the second objection? What does it have to do with the second objection?
But tomorrow that will be done. All that we have done with.
ನೀವು ಯಾವ ಕ್ವೆಶ್ಚನ್ ಕೇಳಿದ್ರು ಬೇರೆ ಏನೋ ಹೇಳ್ತಾ ಇದ್ದೀರಾ, ಏನ್ ಮಾಡೋದು?
By tomorrow we will carry out office objections raised by the office.
2 and 3. What about 4?
I am not trust, my lord.
Learned counsel for the petitioner submits that he does not wish to press IA number 1 or 2020. Hence IA 1 or 2020 stands dismissed. What about item number 5?
That is the memo, my lord. The memo which
The
we
memo.
filed.
A memo dated 17/2/2022 has been filed, stating that during the pendency of the above petition, respondent number 2 has expired. Respondent number 2 and respondent number 17 have expired. And their legal representative, that is respondent number 3, 4, 5. And that, have expired, full stop. Respondent number 3, 4, 5 are the legal representatives of the deceased respondent number 2. And respondent number 18 and 19 are the legal representative of deceased respondent number 17 are already on record. A request is made to treat them as the legal representatives as detailed above. The said request is accepted, memo is allowed.
I make one submission, my lord, as far as R22, 23 and 24 is concerned. But this order under writ is challenged before this honorable court out of FDP proceeding. Suit for partition came to be decreed. The decree is challenged before this honorable court, which came to be dismissed. There is a clear finding in RFA 1479 of 2012 that commissioner should be appointed. Commissioner who has already been appointed and his report is given shall be considered by the trial court. Now the trial court considers the report of the commissioner. That order is under challenge.
Mr. Raghunath, there's an interim order passed.
I understand.
Notice they have been ordered. They have to come on record and do piecemeal.
My lord, 85 is the suit, my lord. Suit of the year 1985.
A review was also filed against the RFA that is not brought to the notice, my lord.
Yaro?
A review was also filed against the said order which learned friend Mr. Raghunath referred to that came to be dismissed. Urging that the review is pending, this writ petition was filed.
Yes, my lord.
Only to frustrate the final decree, the preliminary decree, my lord.
6 months direction in the RFA. 4 months direction.
Having regard to the
That order copy is not produced by my learned friend. Suppressing that order, the writ has been filed. If the Lord permits me, I'll read the last sentence of the order, my lord. The learned judge would work out
Mr. Raghunath, we'll consider all that. Now, respond number 7, 16, and 20 are to be brought on record. Notice has to go.
I understand, but not leaving open the technicalities, but not since we are challenging the order. Suit of 85. The direction is to dispose of within 4 months, my lord. That was on 30th January 2020.
Suit of 85, my.
That order copy is not produced by my learned friend.
FDP proceedings are stalled only by virtue of this interim order.
So, respondent one filed objections, my lord, along with the 3 sets of copies wherein who are respond number 7, 16, and 20?
Still in the court.
Do any of you accept notice for respond number 7, 16, and 20? If you accept notice, you come on record, we'll take up the matter for final disposal. Yeah, respondent 1 is a petitioner, we have filed a partition. Irbodu, sir, it's for status of service of someone. If you want to appear, you appear. We'll take it up. Only because of pendency of the review petition, we make a ground and file this petition. The review petition was also dismissed. You have respond number 7, 10, and 16 and 20. Are they represented in the FDP proceedings? Therefore, they are represented. They are represented. So get them to appear on the next date. If you are in a hurry, get them to appear. The counsel for the petitioner is also directed to serve a copy of the above petition along with all annexures on the counsel for respond number 7, 16, and 20 appearing in the FDP proceedings. The said service shall be made by.
It was served, my lord, to the 16th. There is an acknowledgement to that on 22/2/2020.
ಫೈಲ್ ಮಾಡಿ ಮತ್ತೆ ಯಾಕೆ ನೀವು ಎಲ್ಲ ನಿಮ್ಮ
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ತಗೊಂಡಿದ್ದು ಅವ್ರಿಗೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸರ್ವ್ ಮಾಡೋದಕ್ಕೆ ನಮ್ ಕಡೆಯಿಂದ ತಪ್ಪಾಗ್ಬಾರ್ದು ಅಂತ ವಿ ಸರ್ವ್ಡ್ even to the advocate without even the order.
ಅದು ಫೈಲ್ ಮಾಡಿ ಇಲ್ಲಿ.
That I will file.
ನೀವು ಹಿಂಗೆ ಎಲ್ಲ ಇಟ್ಕೊಂಡು the impression that we are getting is you want to take advantage of the interim order.
I'm sorry, my lord, I was not aware that they are going to raise such issue. And moreover, your lordship kindly appreciate they are discussing about the merits of the case. When the commissioner, the MDP was filed, my lord, I invoke clause preemption. I filed application under section.
You want to argue on merits by giving it up on responsibility?
No, I'm just.
You want to give up, we'll hold that you don't want to serve and we'll take it up.
I will file the copy.
You are taking advantage of the interim order.
Different suit is also been filed now, my lord.
On or before 25/2/2022.
Interim order, ma'am.
Relist on 28, on or before 25/2/2022 and the acknowledgement thereof filed with the registry by 26/2/2022. Relist on 2/3/2022.
Interim order.
Madam. Mr. Manjunath?
But I appear for the petitioner. Last time, my lord, your lordship has issued notice to the government and they said they will file the objection.
Madam? Objections? ಅಲ್ಲ ಓರಲ್ಲಿ ಹೇಳ್ಬೇಡಿ, ನೀವು ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಕೊಡಿ, ಅವ್ರಿಗೂ ಕಾಪಿ ಕೊಡಿ. ಓರಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮು ಹೇಳಿದ್ದೀರಾ. ಈಗ ಯಾವ ಫೈಲ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ. Review petition will be allowed ಅಷ್ಟೇ. ಇವಾಗ ಯಾವ ಫೈಲ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ ಅಷ್ಟೇ ಹೇಳಿ. Then SCGP seeks for a week's time to file an objections. Objections to be filed on or before 3/3/2022 after service thereof on the counsel for the petitioner. Relist on 7/3/2022. ಎಲ್ಲ ಹಾಕಿ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ. ಉದಯ್ ಕುಮಾರ್ ಹೇಳಿ. ಮಿಸ್ಟರ್ ಉದಯ್ ಕುಮಾರ್.
Serial number 16, my lord. I appear for petition.
ಹೇಳಿ.
Yes, my lord. My lord, this is the petition challenging the orders dismissing the application for clubbing the proceedings, my lord. My lord, the brief facts of the case are that, my lord.
What is the stage of the suit, Mr. Uday Kumar?
My lord, my serial number is 16. My name is Murthy, my lord.
Now, what is the stage of the suit?
Yes, my lord. Morning, I tried to contact my advocate, my lord, but I couldn't get the information. So therefore, even in fact, 2017, now we are in 2022. I verified, my lord, but I could not get the information. I will collect the information.
You don't need to contact anybody, Mr. Uday Kumar. Everything is available in e-court website.
Oh, my lord.
ನೀವು e-court website ಹೋದ್ರೆ ಎಲ್ಲ ಡೀಟೇಲ್ಸ್ ಸಿಗತ್ತೆ. Anybody can go and search for it.
Yes, my lord. I will.
ನೀವು ಅಡ್ವೊಕೇಟ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಮಾಡಿದ್ದೀನಿ.
ಕೇಸ್ ಟ್ಯಾಗ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
If you register and case tag in your dashboard, you'll get the latest information. ನೀವೆಲ್ಲೂ ಹೋಗೋದ್ ಬೇಕಾಗಿಲ್ಲ, ಯಾರಿಗೂ ಕೇಳೋದ್ ಬೇಕಾಗಿಲ್ಲ.
There is another connected matter, my lord. One suit, one FTP proceedings. One
ಹೇಳಿ number ಹೇಳಿ.
OS number, my lord.
OS ಅಲ್ಲ connected matter ಇಲ್ಲ ಅಲ್ಲ OS.
ಇಲ್ಲಿ ಈಗ ಲಿಸ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ 16.1 serial number. Cause list ಅಲ್ಲಿ
16.1 ಯಾವ್ದು ಇಲ್ಲ ಅಲ್ಲ ಮಿಸ್ಟರ್ ಉದಯ್. There's only 16. You're Mr. Murthy.
Yes, my lord, I am Murthy.
ನೀವು ಐಫೋನ್ ಅಂತಿದ್ರೆ ಕಷ್ಟ ಆಗತ್ತೆ, ನಿಮ್ ಹೆಸರು ಇದು ಮಾಡ್ಬೇಕು. We are in the first list, we are not in the second list.
I'm sorry, my lord, I'm sorry.
ನಿಮ್ಗೆ ಆವಾಗಿಂದ ಉದಯ್ ಕುಮಾರ್ ಅಂತ ಹೇಳ್ತಾ ಇದೀವಿ, ಇಲ್ಲ, you did not refute it.
Sorry, my lord, sorry. Very sorry.
Cell number 16, Mr. Uday Kumar. ಏನಮ್ಮಾಗಿದೆ? ಫೈನಲ್ ಇಯರಿಂಗ್ ಏನು? ಅದಕ್ಕೆ ಯಾರು ಬರ್ತಾ ಇಲ್ಲ. ಬಿಸ್ನೆಸ್ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗಿದೆ. None appears for the petitioner. In the interest of justice, one more opportunity is granted for the petitioner to appear and address his arguments. Pre-list on 22/3.
Serial number 17, my lord.
Yes.
Lord, aggrieved by the temporary injunction order granted by the first appellate court.
Appears for the respondent.
Lord, from several hearing dates is not appearing, my lord. Only in the first instance.
Already observed that on the last date. Go ahead.
He is also a caveat holder.
Yes, please.
Lord, temporary order, I prefer this writ petition. Lord, it is the case of the respondent plaintiff that he is the absolute owner in possession of agricultural land bearing survey number 730, situated at Srirangpatna village, Srirangpatna Taluk. Out of 91 guntas, my lord, he has converted 15 guntas and he has put a water purification plant. Now, that is scheduled as schedule number A, my lord. And it is his say that in order to access the A schedule property, to access his B schedule property, and according to him, B schedule property is a 10 feet wide and 1,120 feet in length land, which cut through several agricultural land. Now, my lord, it is the specific defense of the petitioner as a defendant, my lord, that the suit of the plaintiff itself is not maintainable because it is hit by section 15 of Easementary Act. My lord, if your honor sees section 15 of Easementary Act, my lord, it says that in order to file a claim right over a land as an easementary right, the plaintiff ought to have enjoyed that property without any interference for more than minimum of 22 years. Here, he became the owner of this A schedule property by virtue of sale deed dated 23/12/2000. Now, the suit is filed in the year 2019, my lord. So it is a premature suit. Secondly, my lord, before the sale deed dated 23/12/2000, my lord, there is not even a single statement which speaks about existence of B schedule property. And
has notice been issued in this matter, Mr. Manjunath?
My lord, caveat holder, my lord.
After that, no notice has been issued.
No, my lord, no, my lord. And Lord, and thirdly, my lord, he has produced. Kindly turn to page number.
No. Wait. You have to first issue notice. There is no notice which has been issued, though caveat has been shown anta order agide. But yavatu notice agilla.
In the first hearing, he appeared. Thereafter, the matter was posted 5 to 6 times, my lord. He did not appear at all.
Illa, yavattu appearance illa.
First occasion he appeared, my lord.
The order sheet does not disclose that.
Oh, okay.
The only 2 dates on which the matter has come. This is the third day.
No, my lord. On VC itself, this is the third time.
Issue notice to the respondents.
My lord, one submission, my lord. Call for LCA may be ordered because there are certain documents which have been produced.
You
which are
produce photocopies, we won't call for the LC. Issue notice to the respondent returnable by 24/20/22. The counsel for the petitioner is also permitted to serve the counsel for respondents in the trial court.
ಹಲೋ, ಕೋರ್ಟ್ ಆಡಿಯೋ ವಿಡಿಯೋ ಎರಡು ಆಫ್ ಆಗಿದೆ.
My lord, court's audio is muted, my lord.
We are unable to hear you.
We restarted our mute.
Yes,
Now you
yes.
can hear us?
Yes, my lord.
Yes, my lord.
Serial.
Lord, serial number 19, my lord, I'm filing a status report with
Yeah,
respect to the fake sureties, my lord. Another submission, my lord, the petitioner number 1 is also no more, my lord.
Petition number 1?
Yes, my lord. He bereaved on 9/1/2022.
Mr. Dalwai?
Legal representatives will have to be brought on record.
So, ಏನಾಯ್ತು ಎಲ್ಲ ಮುಗೀತಾ ಇದು?
My lord, presently, my lord, the fake surety is yet to be identified in this case. The statements of the advocates who have signed for the surety has also been recorded. In the meantime, Mr. Narayanappa's statement was recorded wherein he had given a list of 3 cases, my lord, wherein his documents were used as fake surety. Those documents are now sought to be obtained and case to be proceeded, my lord. In the meantime, his demise, my lord, has brought a full stop to this case, my lord.
Mr. Dalwai?
On behalf of Venkatesh.
Lord, will I file the status report,
Yes,
my lord?
please.
Speak for 2 weeks time to bring the evidence on record, my lord.
Madam?
So we are appearing for petition number 1 and 2, my lords.
Yes.
We speak for 2 weeks time to bring the LRs on record, my lord.
Of petition number 1?
Yes, my lord.
Both have expired?
Yes, my lord. Both the father and the son both have demised. The son passed away last year due to COVID, my lord. The father due to a heart attack, he passed after an angioplasty, he passed away on 9/1/2022. Lord, one more submission.
So they
my lord.
won't get any benefit out of this.
My lord, one more submission. My lord wanted to lay down a guideline with respect to fake sureties. My lord. My lord, on the last date, I have filed a memo I submitted through VC, my lord. I don't think that memo was put up in when my lords were sitting at the Dharwad bench.
Date yavadu?
My lord, this is one circular, my lord. May I pass on, my lord?
Yes.
Helpful in passing an order, final order, my lord. This is one circular from the High Court of Andhra Pradesh, my lord, of 2002, my lord, which I found on the website.
This is a very old one, madam.
Yes,
2002. Now the technology has improved quite a bit.
I
Can we have
definitely.
Aadhaar authentication?
My lord, it could be modified as per the latest technological developments, but this could be used as a baseline to frame guidelines, my lord. That is my submission.
For other authentication,
Yes,
police IT
please, ma'am.
should be able to do the authentication.
My lord, the police IT is not verified to do it under UIDAI, my lord. UIDAI does not give permission to verify the Aadhaar card in the police IT.
Neither the court is authorized.
Pardon, my lord?
Neither the court is authorized for UIDAI.
Yes, my lord. For that reason only, my lord, the other documents and other verifications are also laid down in these guidelines. For example, my lord, it should the solvency certificate should contain the signature of the issuing authority with name and designation and date of issue.
Yes.
And also, my lord, surety should produce the bank passbook or ration card or some other form of identity cards to establish their identity.
And that itself is fake, which is being produced. Other problem. Any document which is being produced, the property
My lord,
document.
if a link is given from the court, my lord, these sureties are given in the court, my lord. And respectful submission is in the court only. So if the court, the district courts or the trial courts are given a permission to verify through UIDAI, it would be better, my lord. If police IT is involved, my lord, once again, there would be a lot of chaos because police IT will have to verify it and the documents will have to reach the police IT. In the meantime, the time when bail is granted and verification would take it would consume some time, my lord. If the verification is done at the court only, by the court officers or by the person who is receiving the surety in the court, it would be much more faster, my
To
lord.
check whether the
Yes, my
system
lord.
can be done or not. We'll check.
UIDAI will have to be involved, central government will have to be involved to verify whether such a permission can be given, my lord, because it is a matter of national security.
And it's a matter of national security, but it's also important for
Yes, my
petition
lord.
like this. Somebody else produces their document, property is sold.
True, my lord.
They don't even know about it.
True, my lord.
Anybody can do this.
This was the only guidelines I found as which could be followed as a base, my lord, and thereafter it can be improved based on the technological development which has taken place now, my lord.
We'll see that.
Yes, my lord.
Let them bring.
Please, my lord. Both petitioner number 1 and 2.
Just report the same on record. The right counsel for the petitioner submits that the petitioners have expired. She seeks for 2 weeks to bring the legal representative of deceased petitioners on relist on 15/3.
Obliged, my lord.
Please, appear for the petitioner in this matter.
Yes, Mr. Vinay.
Suit for partition and separate
Yes,
possession.
Sharat Gowda. Respond number 2. So appears for respond number 1.
My lords, I appear for respond
What
number 1.
happened to settlement?
Settlement days go on, your lordship.
Whose client is not coming?
My lords, I appear for respondent 1, my lords. My lords, my client has agreed for the settlement.
Ready for settlement.
My lords, I appear
Yes.
for respondent 1, my lords. Even my client has agreed for the settlement, my lords. As is
Yes.
unwell. Yes, my lords. As is
What are the
unwell.
terms of the settlement that your client is agreeable?
My lords,
Terms, you know.
my lords, is unwell, my lords. Is not able to discuss with the other petitioner and the respondent number 2, my lords. So
Like, agreeable for a settlement. Is agreeable for the principle of settlement or agreeable for a settlement? The terms idya enadru?
yes, my lords, there is some terms, terms which was already discussed, your lordship. Based on that, he is agreeable.
So what are the terms?
My lords, in Assam, there are some properties, my lords. In those properties, is asking for certain portion of land, and even the petitioner have agreed for that. As per those
So,
terms,
Osmat, is that correct?
Lord, I'll make one submission. There were two proposals given in the mediation center. One was that they will part with 1 acre of land. If they part with 1 acre of land in Hassan district, I have to part with 2 acres in that I have, that will be equivalent to them. That is what the proposal was. That if they give 1 acre there, I will give 2 acres here.
So you are agreeable for that?
Petitioner was not agreeable for that.
So what are you agreeable for?
I'm sorry, Malaj.
So what are you agreeable for, Mr. Vasman?
Now my client says that he is not agreeable for any settlement. He wants to go on with the case.
Okay. So you no settlement now.
No settlement, Your Lordship. That is what he instructed me.
Mr. Gowda, no settlement.
That's all right, my lords.
All the councils submit that the settlement talks have failed and they wish to go ahead with the matter on merits. Ready, na?
Yes, Your Lordship. I'm ready.
Yes. Yes, Mr. Sharad Gowda, ready?
My lords, senior is held up in other court, all my lords. It could be kindly taken next week, my lords.
Relist on 7-3.
Respondents 1 and 2, my lord.
Yes. Ready?
Tomorrow, my lord, please.
Tomorrow,
Tomorrow, my lord. Senior was in my lord. I'll go through the, I have read it, my lord, I'll go through, but subject to that, tomorrow may be accommodated for further hearing. I'll hear the matter.
26 rule 10. Na?
Yes, my lord.
Petitioner prays for and is granted 3 days time. Relist on 28-2. In order earlier granted is extended till next date of hearing.
Please.
Appear for petitioner. I'm ready, my lord.
The Shivswamy?
Last 2 occasions also he didn't appear.
Kandilwa.
Yeah. The same was observed also.
Yes, go ahead. We have observed that if they don't come, we'll take it up.
Yes, my lord. Yes. Lord, the petition number 129 are the impleading applicants before the trial court. They filed application under order 1 rule 10-2, that's IA number 8, to come on record that came to be rejected by the trial.
What is the suit for?
Suit for specific performance filed by the plaintiff against the defendant. And it is the specific case of the defendant that, my lord, defendant has not at all executed any sale agreement in favor of the plaintiff, and he has not received any consideration amount.
Who are you?
It is I'll come to that, my lord. It is the specific contention of the defendant. The suit property is not his property; it belongs to the joint family property, and he has taken that specific contention. These are also legal aids, and we being the legal aids, my lord, we also have a specific our share in the suit property. So we filed the pleading application to come on record. The trial court has given observation that, my lord, that issue cannot be decided in the suit for specific purpose.
Either if he has a share, the agreement would be for only his share. Specific performance will be of that. He doesn't want you. So you are safeguarded by this order.
No, the thing is, my lord, if this court go ahead, my lord, it decrease the suit, my lord, and if it execute the sale deed, my share also it leads to multiplicity of proceedings.
Only his share can be sold, not your share.
Yeah, that's why I should be come on record to.
Not necessary. You're not a signatory.
Yes, I'm not signatory, my lord.
You won't be bound by any decree which is going to be passed.
Yes, my lord. The thing, I
no
really
relief asked against you.
Yes, one decision of the apex court, my lord, this court, that's Justice Honorable Justice A.S. Bopanda sir judgment. Similar case, my lord, just 2 lines. Applicant seeking to come on record contending that the suit study property was accepted and the defendant has no right to execute agreement. Considering nature of the right claimed, applicants cannot be considered as strangers to the suit. By allowing this application, trial court did not commit any error. And just 2 lines, my lord. Even if ultimately the agreement is found to be valid, it would be only to the extent of the share of the existing defendant who has signed the agreement, executed, and the applicants are allowed to remain on record. They would be entitled to bring the same on record. Therefore, I do not.
At the end, Mr. Sridhar.
Yes, ma'am.
So we'll observe that and dispose of your writ petitions that it is restricted only to that.
Yes.
So,
Yes.
petitioner is before this court seeking for the following leaves. OS number 360 of 2008 had been filed by respondent number 2 herein, seeking for a specific performance of an agreement of sale said to have been executed by respondent number 1 in favor of respondent number 2 on 17/6/2005. While the suit was pending, the petitioners herein filed an application order 1 Rule 10 bracket 2 of the Civil Procedure Code to be brought on record as additional defendants on the ground that the property which is subject matter of the agreement of sale dated so and so is not the exclusive property of the respondent number 1, but belongs to the petitioners and respondent number 1, it being a joint family property. The said application came to be objected to by a plaintiff therein, who is respondent number 2 herein. After considering the matter, the trial court dismissed the application on the ground that there is no relief which has been claimed against the impeding applicants. The issue as regards joint family property or otherwise is not relevant for the purpose of deciding the suit for specific performance. It is agreed by the same that the petitioner is before this court.
One last submission, my lord. In order to resist the suit, my lord, to establish my right over the suit schedule property, my lord.
We will make an observation on
yes,
that.
we
We'll make an
have to.
observation.
Yes.
Sri A.G. Sridhar, learned counsel for the petitioner, will submit that under the guise of the agreement of sale and the suit, the property of the petitioners would get affected inasmuch as the same is the subject matter of the agreement of sale and the suit for specific performance. Therefore, he submits that the petitioners ought to have been allowed to come on record and contest the suit. None has appeared for the respondent. On earlier occasions, also there was no representation in this court, while order dated 7/2/2022 had observed that if none were to be present for the respondent, the matter would be taken up for consideration in their absence. Heard Sridhar A.G., learned counsel for the petitioner, and perused documents. The suit in OS number 360 of 2008 is one for specific performance of an agreement of sale of a property in which the petitioners claim interest. The petitioners admittedly are not signatories to the agreement of sale dated 17/6/2005, nor have they been arrayed as parties in the said suit by the plaintiff. Thus, there are no reliefs which have been sought for against the petitioners in the said suit. Needless to say that any decree passed in the said suit would not be binding on the petitioners herein. The petitioners had voluntarily filed an application under Order 1 Rule 10(2) for the CPC to be impeded as party respondent, which has been objected to by party defendants, which has been objected to by the plaintiff. And as such, the said application came to be rejected. So the plaintiff is aware of the rights of the petitioner, alleged rights of the petitioners in the property subject matter of the suit. Despite the said knowledge, the plaintiff, respondent number 2, has opposed they being brought on record as party defendants. Thus, once the plaintiff is aware of the existence of the petitioners and having opposed their impleadment, the plaintiff cannot seek to enforce the decree, if any, passed against the petitioners herein. As observed here and above, no relief has been sought for against the petitioners herein, nor are they signatories to the agreement of sale sought to be specifically enforced. Hence, I have the considered opinion that the plaintiff in the suit, not wishing to prosecute the proceedings against the petitioners herein, the order passed by the trial court is proper and correct and does not require any interference.
Well, in this case, appealing for the respondent, my lord.
Yes. Mr. Shastri. The learned counsel for the respondent is present. None appears for the petitioners. Relist on 16(3).
My lord, this is not maintainable, my lord. They are challenging the order passed by trial court on 7 Rule 11A, my lord. They have to file the
CRP Act.
Yes, my lord. File application for decision of plaint, my lord.
No counsel for the none appears for the petitioner. Learned counsel for the respondent submits that the above writ petition is not maintainable, since what is challenged in the present writ petition is the order dated 3/9/2016 passed on IA number 2 and order 7 Rule 11 bracket A read with section 151 of the CPC in OS number 2292 of 2016. By virtue of the said order, the application and order 7 Rule 11A came to be dismissed. There is merit in the submission made by learned counsel for the respondent. The writ petition would not be maintainable to challenge the rejection of application order 7 Rule 11 bracket A. Since the petition is dismissed as not maintainable, liberty is however reserved to petitioner to file necessary civil revision petition. If so advised.
Much obliged.
For the respondent, number 1, first.
Respondent number 1.
1 and 2. First respondent number 5. In 4883, I'm the petitioners.
And you are for?
And for respondent number 5 in WP 5900/2017. And respondent number 4 in WP 4883.
Where is Mr. Trimurti? Mr. Trimurti?
He was here only. He was here only.
Illidra?
ಮಧ್ಯಾಹ್ನ ಆಯ್ತು.
ಇವಾಗ್ಲೂ ಮಧ್ಯಾಹ್ನ
ಅಲ್ಲ 2:30 ನಂತರ ಆಯ್ತು.
ಡೇಟ್ ಕೊಡೋಣ ಅವ್ರಿಗೆ ಇದ್ರು. Dole learned counsel for the respondent in WP number 5900 of 2017.
It's a matter of 2000.
ಅವ್ರು ಇದ್ದಿದ್ರೆ ತಗೊಂಡ್ಬೋದಾಗಿ. ನೀವೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವ್ರು ಇದ್ರು ಅಂತ. Should not do that. So the counsel for respondents are present. None appears for the petitioner. In the interest of justice, to give one more opportunity for them to be represented. Pre-list on 8(3). So Prakash?
My lord. I am for the petition, my lord.
Yeah, respondent here.
My lord, may I make a submission, my lord?
Yes, Mr.
My lord, before the trial court, the case has arrived to the stage of arguments, my lord, day after tomorrow. Therefore,
nothing, no purpose will be served.
Yes, my lord. And it may be observed, my lord, without influence of this order, the trial court may be dispose of the matter in accordance with available evidence and record.
Before commencement of arguments,
yes,
on inquiry, Sri Umesh Mullimani, learned counsel for the petitioner, submit that the suit before the trial court is now posted for arguments on
23 February 2022.
23/2/2020. Final arguments on 23/2/2020. In my considered opinion, there would be no purpose in considering this writ petition, which challenges the interlocutory order. Hence, the writ petition is dismissed with the observation that the trial court shall consider the matter without being influenced by any of the observations made in the order under challenge.
Please.
Lord, I pay for the petition in this case, my lord.
Mr. Sigri?
My lord, I appear for respondent number 1.
Yes.
Lord, Lord, appeal against OS 26 of 1919 was not preferred before the Honorable Civil Judge, Lord, by the defendant appellant. Lord, this appeal was dismissed for default, but I had sought for readmission on 41 Rule 18. Lord, this application is negated by the Honorable First Appellate Court, holding that you were not negligent, my lord. Hence, there is no question of readmitting the appeal. And that, my lord, agreed with that, my lord. MA was filed, MA 19/9, my lord, 2006, my lord.
MA?
Miscellaneous 24 is the application filed under 41 Rule 19, seeking readmission of the appeal dismissed for default. Page number 42, my lords, Annexure C. Page 42, my lord.
Yes.
Petition order 41 Rule 19, so and so. The petition appellant most humbly prays that some please to restore the appeal RA 50 of 11, which is dismissed on 28/5/2011 by allowing this petition. So this application
RA 50.
RA 50, my lord, is
Where
the
is the
original.
order?
Please, my lord, that is the order of First Appellate Court dismissing the appeal for default.
Where is that order, Mr.
I shall now, please. Orders at my lord. Page 44, my lords.
44 is miscellaneous 24.
Please, miscellaneous for 24, my lord.
RA
RA was
order
dismissed on
produced
28/5/11, my lords.
Yes.
Lord,
yes.
I'm how to make the submissions, my lord. Of course, both do consider that is dismissed for default. Of course, my lord. 28/5/12 is the order of dismissal.
Default for non-appearance, huh?
Please, my lord, non-appearance.
Okay.
Hence, my lord, we sought for readmitting the appeal under 41 Rule 19, my lords, by giving reasons, my lord, annexure. But the Honorable First Appellate Court says that this is the order, my lords. Reasoning is at page 46, my lord. 46.
Yes.
Reasons. There was the entire record's evidence of petition, both oral and documentary, and arguments addressed by learned advocate parties. Admittedly, this petition filed by petition for restoration of RA 50 of 11, which came to dismissed on 28/5/2011 for consideration of appeal on merits. No doubt it is true that respondent number 1 appeared through his advocate, but not contesting the petition. In order to discharge the burden of the petitioner, both the petition and evidence of appeal 1, it is contention of the petitioner that respondent filed OS 226 of 1994 on the file of Honorable Principal Civil Judge Junior Division, Malur, and after its contest, the said suit was decreed in favor. Agreed by the judgment and decree, the petitioner herein preferred an appeal in RA 50/2011, old number so and so. The petitioner advocate by name V. Vishwanath could not able to appear before the Honorable Court on 25/5/2012 when the matter was posted for arguments. The petitioner was intimated the stage of case. At the time, the petitioner advocate sincerely requested the petitioner to take a short adjournment on 2/6/2012. And also he has advised that he will go into finish the arguments on merits that day itself. The same was intimated to junior advocate N.B. Sarvesh at Malur to take an adjournment on 2/6/2012. But this Honorable Court has rejected his prayer and dismissed the appeal on 28/5/2012. The said reasons was bona fide and not intentional one, not deliberate part of the advocate, nor the part of the petitioner. This is the contentions of the Lord appellant petitioner before the Lords. Then, Lord, coming down, Lord, the above said stand of the petitioners remains uncontroverted and the evidence of evidence unchallenged, unassailed. Coupled with his oral testimony, he has produced so and so and so, where it disclosed that the petitioner has taken time for arguments, not only for 2 or more hearing dates, but he has taken time to address arguments since from 1/1/2007. Further, on 28/5/2012, order sheet disclosed that the appellant was absent and the learned advocate NBS appeared for the appellant request time for arguments. His prayer was rejected and this appeal was dismissed for default. Further, in order to prove the petitioner government, the petitioner has not produced the affidavit of the learned advocate who appeared for him in respect of the petitioner, approached the said advocate and obtained instructions to take adjournments up to 2/6/2012. Non-production of materials believable supporting affidavit, it is not safe to accept the alleged instructions obtained by the petitioners. Moreover, at the evidence of PW1 also, he has falsely stated, in spite of having knowledge of the order sheet dated 28/5/12, wherein it is clearly mentioned appellant absent. At this stage, this court opined that petitioner has come up with the clean hands to request for restoration of RA 15, which was dismissed on so and so. Then the findings part, viewing for any materials, interior materials of the facts and circumstances placed on record, coupled with order sheet so and so, the petitioner has filed this petition false reasons, which cannot be acceptable for considerations. No doubt it is true that learned advocate for the respondent, number 1, submits no objection to allow this.
What do you say?
Pardon? No,
What do you say?
that miscellaneous has been dismissed about 5 years back. And my lord, I guess that order and appeal is also provided under order 43, order 43, my lord. There is an alternative remedy available.
What we see is that your counterpart has said no objection to allow the miscellaneous petition, despite which the miscellaneous petition was rejected.
No, that's fine, my lord. Lordship, I can say after so many years she has filed it. The latches also, Lordship, I have to see it.
So, Ivaga, because of latches, you want to oppose this.
And there's alternative remedy.
Was, order passed on.
Decrees on 21/6/2006 is the decree, my lords. RA was filed on 11/6/2006. My lord, absolutely no delay. It is exactly in time, my lord.
30-10. Illa, nim time illa.
Allah, but your lordship, alternative remedy is available.
Lord, I would, my lord, very fairly submit that. My lord, I would make out with compensatory cost so that, my lord, it could be, it is not on the merits of the matter. Ultimately, my lord, a decree for civil rights, I mean, civil properties will grant it.
Your lordship may not say that I have considered any of the lordship may kindly pass appropriate order, maybe with heavy cost.
With cost, I would, my lord, honestly, my lord, agree for that, but not compensatory. It's all a poor lord farmers. Lord could see that annexure C is, my lord, no more now. Please, my lord, I request, my lord.
Yes, Mr. Ramesh. The petitioner is before this court seeking for the following reliefs. RA number 50 of 2011 had been filed challenging the judgment decree passed by the Principal Civil Judge Junior Division, Malur in West number 26 of 1994. They said RA came to be dismissed. On
11/8/2006, my lord, is the RA. Dismissal on 30/10/2012. Please, my lord.
For default. Agreed by the same, miscellaneous 24 of 2012 was filed, seeking for restoration. All said RA number 50 of 2011, contending that on the fateful day, the counsel for the petitioner could not be present, and though an adjournment was sought for, the same came to be refused by the trial court. The miscellaneous petition also came to be dismissed on the ground that the miscellaneous petition is not supported by an affidavit of the advocate who had appeared in the matter. And as such, the trial court held the petition to be lacking bona fides. This agreed by saying that the present petition has been filed. Shri Ramesh Kumar, learned counsel for the petitioner, would submit that on the date of dismissal, that is 28/5/2012, it is not that none had appeared for the petitioner. A junior lawyer had appeared and requested time for arguments on account of the non-availability of the arguing counsel, which came to be rejected and the appeal was dismissed for default. He therefore submits that the same has caused severe injustice to the petitioner, and as such, miscellaneous petition was filed, which ought to have been allowed and not to have been rejected only on the ground that an affidavit of the arguing counsel was not placed on record. Shri Veeranaji Tigdi, learned counsel, appearing for respondent number 1, submits that the order before this court is of the year 2011, and there being full lapse of time, this court ought not to intercede in the matter and consider the application for restoration of the RA.
Alternative remedy of the justice.
We also submit that there is an alternative remedy in terms of an appeal under Order 43, Rule 1.
The Order 43 rule. Yes, ma'am. F on that one.
One,
one there. Just yes, no, that is F melon, T. Subclause T of 43 melon. Order 43.
43, Rule 1.
T for tiger melon.
Rule 1T.
To avoid that limitation, he has filed a petition. It appears
that the petition ought to be rejected. The present writ petition was filed in the year 2007. Heard Shri Ramesh Kumar, Shri Veeranath Tigdi, produced papers. The present writ petition has been filed in the year 2017. At this stage, I am of the considered opinion that the argument of Shri Veeranath Tigdi that there is an alternative efficacious remedy in terms of appeal, in terms of Order 43, Rule 1T, will not come in the way of this court considering the matter, since the present writ petition itself has been pending for the last 5 years. As regards the merits of the matter, though there is serious opposition by Shri Veeranath Tigdi, a parallel of para 10 of the impugned order indicates that the advocate for respondent number 1 had submitted no objection to allow the miscellaneous petition number 24 of 2012. It is rather surprising that when the respondent himself had no objections to allow the miscellaneous petition, the court has rejected the said miscellaneous petition, leading up to this particular matter being pending for the last 12 years now. When the respondent itself had no objection at that stage, now the objection of the respondent, in my considered opinion, cannot hold any water and cannot be countenanced. In view thereof, I pass the following order. The writ petition stands allowed. The order dated 27/2/2016 passed in miscellaneous appeal number 8 of 2015 by the second additional district and session judge at Kolar, Annexure F, is hereby quashed. Miscellaneous number 24 of 2012 is allowed. RA number 50 of 2011 is restored to the file. The submission of Shri Ramesh Kumar RV, Senate Counsel, appearing for the petitioner that he would not take any unnecessary adjournment in RA number 50 of 2011 and arguments would be advanced on the very next date is placed on record. Considering that the suit is pending, that the RA has been pending for, RA is of the year 2011, the trial court is directed to dispose of the same as expeditiously as possible after hearing both sides.
So, may I know when is the date to appear? I'm not here.
We haven't fixed a date.
Yes.
Considering that both the councils are present before this, and both the councils are directed to appear before the trial court, before the first appellate court on 7/3/2022.
Obliged, my lord.
Great.
Obliged, get.
Mr. Basaraju?
My lord, I'm for the petitioner, my lord.
Yes.
Week's time may kindly be granted, my lord.
Execution is taken. Suit for specific purpose decreed. Subsequent purchaser challenges the execution and there is. After the decree he purchases, he has no locus standi at all.
Stiff opposition to your request.
My lord, 1 week time, my lord. My senior is held up in quota number 3, my lord.
Learned counsel for the petitioner seeks for and is granted 1 week's time despite the opposition, serious opposition by Sri P. N. Harish, with the observation that no further adjournment would be granted on the next day.
Yes, my lord.
And if no arguments are advanced, the writ petition would be liable to be dismissed for non-prosecution. Relist on 2/3.
Till that time, my lord, interim order may kindly be extended, my lord.
Is extended till next date.
Much obliged, my lord.
To appear for the petitioner.
Mr. Bhatt?
And last date also he did not appear. My lord, the trial court has summoned a non-existent and irrelevant document and to be produced by general manager of a bank. It's a time-barred debt. Loan transaction is alleged to have taken place in the year 1994. Suit is filed in 2010. And it is not the allegation of the plaintiff that bank manager was a witness to the loan transaction. They say that there was a passbook transfer, account transfer was made in the year 1994. And that entry, they wanted that to be produced when the matter was totally, trial was over, matter was about to be posted for arguments. At that stage,
you tried to save 15 days and you got stuck for 5 years.
My lord, it is not inexistent. It will go on forever.
That is for that witness to come and say it.
The banking law says, my lord, the banking company's period of preservation of records tools. It says only for 6 years. So 94 plus 6 years, 2000 it would have gone. They are summoning it in 2016. That is 23 years later than the transaction, which is not there.
Om Kumar.
Yes, my lord.
Bank manager would have come and said it's not there.
In a general manager, they'll just go on dragging on because it's only to harass the widow who is aged around 77 years and non-existent and irrelevant document. For a loan transaction, this account transfer is no consequence. And then at the first instance, 94 transactions, suit is filed in the year 2010. And after the trial is over in 2016-17, they file an application after their evidence is over. And they say the reasoning, my lord, may kindly turn to page 26. To be precise, I can go to 27.
Para 7.
This is a suit of the year 2010, and when the matter is posted for cross-examination of DW1, the learned advocate for the plaintiff has filed IA number 8 under Order 16, Rule 1, read with Section 150, praying the court to issue summons to General Manager, Tyagaraja Cooperative Bank, number 5, 9th Cross, NR Colony, Bangalore, to appear before the court along with documents regarding transfer of money from plaintiff's bank account to the bank account of Lakshmipati Rao, who is dead in 99 itself, 2000, the husband of defendant number 1. In her cross-examination, DW1 Radhamma, who is the defendant number 1, denied all averments made in the application and denied the loan transaction between her deceased husband and the plaintiff. Under these circumstances, the plaintiff has no other way except summoning the General Manager, Tyagaraja Cooperative Bank, to prove his case. Well, plaintiff has to prove his case with the documents he can produce, and with this one, he cannot scout for evidence for a alleged loan transaction after 23 years. And now it is 28 years, and that document will definitely not be available.
No. The contention that the loan is still subsisting.
Merely issuing summons that will not amount to collection of.
Is the loan still subsisting?
My lord,
Is the loan still subsisting? To discharge the loan and kill.
there's no loan at all. My lord, may I kindly turn to synopsis page 2, my lord. My lord, the alleged loan transaction is 1994.
Yes.
The alleged loaner is a tenant under me, running a tailoring shop in 8/10. And he had filed a suit for bare injunction in OS number 3897 of 2002. There was no whisper of this loan transaction.
The only question that we are asking you
Yes, my lord.
is, as per the suit, the contention is that the loan is still subsisting and is asking the defendant to discharge the loan. So if the loan is still subsisting, no document can be destroyed, whether 94 or 48.
The bank has not given the loan. My lord, bank is.
So can we decide that on this application? Let the bank come and say it.
No,
If
no, my lord, bank is irrelevant party. There is no allegation in the plaint or anywhere that a bank loan is there. No, that's not the case.
That is the claim in the plaint.
No. He says that Lakshmipati Rao, the late Lakshmipati Rao, borrowed money from him. That is his owner. He has to pay the accrued rents. My lord, may kindly see the 4 litigations I'll mention. OS 3897 by 2002 filed by the tenant against the landlord.
You are the children of Lakshmipati Rao, wife and children.
Yes, my lord, wife and son.
Son of
So he
Lakshmipati Rao.
filed a suit against wife and son after his death 3 years later for asking for protection against unlawful disposition of his property. There he did not mention about the loan transaction. Then an HRC case was filed, HRC 415 of 2002. In the defense, he did not raise that even when we said that accrued rents are there. He did not say that I have given loan to your husband, so I need not have to pay. No, it was not his case. And matter came before this honorable court twice in HRRP 321 of 2003 and HRRP 514 of 2006. In all these matters, it was silent. Nowhere there was a whisper of this loan transaction. Nowhere he said that there's a loan which I have given.
We are not concerned with that, Mr. Kumar. That's a different proceeding. This is a recovery proceeding.
My lord, it's a time-barred debt, and as it is, that suit is not maintainable. And asking for a irrelevant document and which is non-existent. My lord, may kindly see that the bank is bound to maintain that only for 6 years. Page 20, my lord, banking rules.
If the transaction is closed, 6 years. If the transaction is subsisting.
No, there's no transaction with the bank. It's only SP entry.
But the relief
savings bank entry. But there's no bank loan. This particular loan transaction is a private loan transaction. Alleged loan transaction is
between come to page 41. Page 41 again.
Page 20.
41. Please read the prayer in the suit.
Wherefore, the plaintiff in the suit respectfully prays that the honorable court may be pleased to pass judgment and decree declaring defendants 1 and 2 are liable to discharge the loan amount that had been got sanctioned by the husband of the first defendant, namely KV Lakshmi Rao, to the extent of 4 lakhs and utilized by the defendants 1 and 2. And we said this is KV Lakshmi Rao, which is now amounting to his 4 lakhs. And for further judgment and decree, the defendants 1 and 2 have succeeded to the properties of the deceased Lakshmi Rao to pay the said. This loan is cleared long back. This loan is not subsisting. I did not get my lord's query. Sorry, I have my apologies. But this loan has been cleared long.
Read the prayer first. But the prayer is different. That is determined after.
They are amounting to rupees 4 lakhs by now, or in the alternative by way of direction to the defendants 1 and 2 to discharge the said loan amount with interest accrued thereon by making payment directly to the Tyagaraja Cooperative Bank and to pass such other necessary orders as this honorable court deems fit and necessary deems are necessary under the circumstances of the case. Well, this loan has been cleared by him.
Can we? You are saying that.
This loan is not in existence.
You are saying that.
It is not his case also. He wants only that savings bank account transfer details have to be produced. That's what he says.
The prayer here is to pay directly to Tyagaraja Cooperative Bank.
I'm neither the borrower nor the surety. There is no I'm not.
You have
party to
succeeded to the estate of your husband.
My husband is also not a party, not a surety, and
Let
he's
that
not
come.
the borrower.
We won't interfere with this.
He is not a borrower, my lord.
That will be determined after the documents come there. After trial.
No, that is not his case also. My lord may have it on some other day. I'll just read the entire, this one, he is not a borrower. He is not a borrower and he is not a surety. And this bank loan transaction with the plaintiff, it has got nothing to do with Lakshmipati Rao and his family. He was only a tenant under us. He was running a tailoring shop. And initially he filed.
Your prayer ಓದಿದ್ರಿ ನೀವು. You are speaking of a different proceeding. We are concerned with only this suit.
Yes, my lord.
Whatever those proceedings are, they are different. ಇಲ್ಲಿ ಏನಿದೆ, there is a suit filed for recovery of money or discharge of the loan to the bank. The contention is that the bank loan is still subsisting. Your contention is 6 years, the documents are destroyed. If the loan transaction is still subsisting, they cannot destroy it. Let them come and say what.
This is not part of the loan transaction, my lord.
We'll see what they come and say. The petitioner is before this court seeking for the following relief. The suit in OS number 2707 of 2010 have been filed seeking for the following relief, page 41. In the said suit, the plaintiff filed an application under Order 16, Rule 1, read with Section 151 of the Civil Procedure Code, seeking for summons to be issued to the General Manager, Tyagaraja Cooperative Bank Limited, to produce the documents regarding the transfer of money from the plaintiff's bank account to defendant's husband's bank account as regards the aforesaid loan account mentioned sought for, as regards which prayer has been sought for in the plain. The said application was objected to but came to be allowed by the impugned order. The said Sri Om Kumar, Learned Counsel for the petitioner, would submit that there is no loan transaction between the petitioners and the respondent.
Petitioner and the respondent, and petitioner and the bank also.
As also the petitioner and respondent, or between the first petitioner's husband and the respondent. Furthermore, the petitioners have not taken any loan from Tyagaraja Cooperative Bank Limited as claimed for in the plain.
Nor did they stand surety for the loan taken by
Nor
the
have they stood surety to any such loan.
Taken by the respondent.
Any such loan, full stop. He further submits that even according to the plain, the transaction is of the year 1994. Therefore, no documents would be available with the bank for the purpose of production.
Regarding transfer of
and as such,
of SB
the
account.
trial court ought not to have allowed the application under Order 16, Rule 1, and summon the general manager of the bank with a direction to produce the documents regarding the transaction. None appears for the respondent. This court would order dated 24/1/2022 that observed that if none, taking into consideration that none were appearing for the respondent, had observed that if none were to appear for the respondent today, the matter would be taken up for hearing. Hence, the matter was taken up for hearing. Correct. The suit is one for recovery of money and or in the alternative for direction to the defendant to discharge the loan amount with Tyagaraja Cooperative Bank. There are various allegations made as regard the nature of the loan transaction and how the loan was obtained. For and on behalf of Sri K.V. Lakshmipati Rao, who is undisputably the husband of the first petitioner and father of the second petitioner herein. Whether there was in fact a loan transaction or not would have to be determined after trial.
Trial is over, my lord. Plaintiff side closed, defendant side closed.
Then only application can be made for.
Please, when the someone trial, the trial court has summoned the general manager of Tyagaraja Cooperative Bank Limited, whom admittedly there is a bank account, and the relief sought for is for discharge of the loan with the said Tyagaraja Cooperative Bank Limited. But in view thereof, I do not find any infirmity in the order of the trial court. It is for the general manager on appearance to state whether there is a bank, whether there is a loan transaction or a loan account, and if the documents are available or destroyed. The same cannot preclude the trial, the same could not have precluded the trial court from passing the orders as impugned in this proceedings. In view thereof, there being no merits in the above petition, the petition stands dismissed with the above observations.
My lords, I appear for the first respondent.
I didn't have that. We'll have it on another day, sir.
Very well.
Due to paucity of time, the matter cannot be taken up for consideration. Released on 8/3, interim order earlier granted is extended for till next date of hearing.
Now, next matter also appear for next matter 23rd.
33. Execution disposed of. Mr. Alisha, the 33 ಅಲ್ಲಿದ್ದೀರಾ ನೀವು?
23 lord.
23 ಆಗೋಯ್ತು ಇವಾಗ 32, 33 ಅಲ್ಲಿದ್ದೀರಾ?
33 I am appearing. 33 I am appearing for the petition.
The execution petition, I believe, has been disposed of. As fully satisfied. ಮೊನ್ನೆ ಅದಕ್ಕೆ ಈ ಕೋರ್ಟ್ಸ್ ನೋಡ್ಕೊಂಡು ಬರ್ಬೇಕು. WPCPC. There won't be any embarrassment at all. The perusal of the e-court website indicates that the execution proceedings 95 of 2013, out of which 95 of Yarama Party Yarama Swami Ranga Shetty. 95 of 2013, out of which the above writ petition arises out of, has been disposed of as fully settled by order dated 19/2/2022. Considering the same, there would be no purpose served by retaining the above petition, and the above petition is dismissed as in practice.
Sorry to again, my lord, if 23rd is urgent, my lord, interim order to be extended. If at all nothing is happened. 23rd, my lord, serial number 23rd.
23rd dismiss ಆಗಿದೆಯಪ್ಪ.
Lord.
Not maintainable. CRP ಹಾಕ್ಬೇಕು.
Serial
7
number.
rule 11A.
Please, my lord.
Serial number 40.
At least, instead of my lord, I may permit to convert this writ petition to
Convert ಆಗಲ್ಲ, CRP ಬೇರೆ grounds ನೀವು ಲಿಬರ್ಟಿ ರಿಸರ್ವ್ ಮಾಡಿದೀವಿ.
Please, my lord. Much.
35 on 22/3.
Respondent.
35 3/3.
This is a case where, my lords, the suit came to be dismissed for non-payment of court fee, holding that, my lords, limitation.
36 23/2.
23
ನಾಳೆ
after tomorrow.
ಅದೆಲ್ಲ ರಿಸರ್ಚ್ ಮಾಡಿದೀರಾ ಅದು?
Supported by one Supreme Court and one Madras.
38 16/3. 18/3.
I am for the petition, my lord.
Yes, Mr. Bond. 21/3.
21/3.
Interim order ಇದೆಯಾ?
Interim order ಇದೆ.
Interim order ಇಲ್ವಾ? ಇಲ್ವಾ ಅಂತ ಮಿಸ್ ಮುರಳಿ ಮನೆ?
No, my lord.
21/3.
Is there, my lord?
Time to time it was extended, my lord.
ಇಲ್ಲ ಅಂತೆ ಅದರ ಶೀಟ್ ಅಲ್ಲಿ.
My lord, even 10 to 2022,
Okay.
18 to 2022 it was.
19/8/29. ಇಲ್ಲ Mr. Mullimani, there was no interim order ever.
I will verify.
For it to be extended. ಯಾವತ್ತೂ interim order ಇರ್ಲಿಲ್ಲ.
I will verify. Sorry.
22/3. 22/3.
This one,
22nd March.
it's a short it's reached after quite some time. Any other?
ಇವತ್ತೇನೋ ಬಹಳ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಅಷ್ಟೊಂದು ಜಾಮೂನು ಕಷ್ಟ ಆಗುತ್ತೆ. 23/3 disposed of. Disposed ಅಂದ್ರೆ ಬರಲ್ಲ ಜನ. The perusal of the e-court website indicates that the suit in verse number 374 of 2012, out of which the above repetition arises out of, has been disposed of as dismissed, has been dismissed on 28/10/2017. None appears for the petitioner, considering that the suit itself has been dismissed. The above repetition does not provide consideration after the repetition stands dismissed.
Appearing for petitioner, my lord. I am filing the memo.
The counsel for the petitioner files a memo.
Also on submission, liberty to file the comprehensive suit, my lord.
ಇಲ್ಲಿ ಲಿಬರ್ಟಿ ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗತ್ತೆ? Suit is dismissed first. ಆಗಲ್ಲ.
What the plaintiff has thought that.
Counsel for the petitioner has filed a memo enclosing the order dated 17/2/2022, by virtue of which the suit has been dismissed. Suit in OS number 53 of 2017, out of which the above petition arises out of, has been dismissed. The said memo and submission of the petitioner are taken on record. The writ petition is dismissed as infructuous.
Liberty to file the comprehensive.
ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ ಹಾಕೊಳ್ಳಿ. ಇಲ್ಲಿ ಹೆಂಗ್ ಕೇಳಕ್ಕಾಗತ್ತೆ?
My lords, I appeal for the petitioner, my lords.
Yes, Mr. Sampath, we'll have it on another day. 21/3.
My lords may dismiss the writ petition, my lords.
ಏನಾಗಿದೆ?
It's a misconceived writ petition, my lords. I went through the position of law. It's a misconceived.
23/2 released on 23. ಇವತ್ತಾಗಲ್ಲ 23/2.
Good.
Yes, Mr. Vadraj.
What has happened is that
Awaiting service.
and is posted before the trial court on 23rd. The contest is then between the DW3, who is defendant number 1, who is claiming certain property and certificate property. I have not been allowed to cross-examine him fully. The trial court says that there is a collusion between me and DW1. There is no material to show.
ಸರ್ವಿಸ್ ಆಗ್ಬೇಕಲ್ಲ ಇದೆಲ್ಲ.
Pardon?
ಸರ್ವಿಸ್ ಆಗಿಲ್ವಲ್ಲ?
ಇಲ್ಲ ಆಗಿಲ್ಲ ಅಂತಂದ್ರೆ ಏನಾಗಿದೆ last time your lordship directed handsome mercy. The department said let the summons come if we had given earlier, let it come back in this thing.
ಆಯ್ತು, ಇದ್ರಾಗ ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ಲ ಅಂತಾರೆ, ಆರ್ಡರ್ ಕಾಪಿ ತಗೊಳ್ಳಿ.
Suspicion is that plaintiffs want to
ಇದೆ ಇಲ್ವೇ ಇಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ಈಗ ನೋಡಿದ್ರೆ
they are deliberately avoiding this.
ಐವೋ ಇಲ್ವೇ ಇಲ್ಲ ಅಂತ.
Permit you to serve the counsel for the responsible trial court.
ಇಲ್ಲ ಉಮೇಶ್,
At least in the meanwhile, some stay out is granted for the proceedings.
ಇವಾಗ ಆಗಕ್ಕಾಗಲ್ಲ. 6 ವರ್ಷದಿಂದ ನಿಮ್ಗೆ ಏನೋ ಸ್ಟೇ ಸಿಕ್ಕಿಲ್ಲ, ಇವಾಗ ಸ್ಟೇ ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗತ್ತೆ?
Because if the matter is heard on 23rd,
ನೀವು ಪ್ರೋಸೆಸ್ ಫೀ ಕೊಡಲ್ಲ,
The petition becomes infructuous, my lord.
You haven't paid the process fee till now, Allah, Mr. All that. The process fee no kodalla, ನಿಮ್ಗೆ entry ಮಾಡಬೇಕು ಅಂದ್ರೆ ಹೆಂಗಾಗತ್ತೆ? ನೀವು ಸ್ವಲ್ಪ ಅರ್ಧ ದಾರಿ ಬರಬೇಕು. Process fee ಕೊಡಬೇಕು. Learned counsel for the petitioner is permitted to serve the counsel for respondent number 1, 3, 6, 9 and 10 before the trial court. R5 is deceased.
This respondent 5 is deceased. And in the trial court, they were LRs were brought on record and they have remained ex parte there.
ನೀವು ಏನಾದ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಊರಲ್ಲಿ ಹೇಳಿದ್ರೆ ಹೆಂಗಾಗತ್ತೆ? Learned counsel for the petitioner seeks for 2 weeks time to take necessary steps as regard deceased R5. Relist on 14/3.
My lord, I have filed an application, my lord, to bring the LRs of deceased petitioner number 1 and 2 on record.
What is the objection, Mr. Vivek?
Appears that, my lord,
Delay ante.
Delay and abatement would not arise, my lord, in view of the Supreme Court judgment, where, my lord, the limitation has been extended even to interlocutory applications, my lord, between the period 15/3/2020 till.
Registry has raised objection as regard delay in filing IA-1 of 2022 to bring the legal representative petition number 1 and 2 on record in view of the decision of the apex court that all the delay caused in filing any interlocutory application during the COVID period is also condoned. There is no, I am of the constructive opinion, there is no delay in filing the said application. In view thereof, accepting the reasons stated in support of IA-1 of 2022, IA-1 of 2022 is allowed. The persons named in IA-1 of 2022 are brought on record as legal representatives of petition number 1 and 2. And counsel for the petitioner to carry out necessary amendment to the petition and for the file amended petition. After service thereof and the counsel for the respondent. Relist on 21/3.
I'm grateful, my lord. Interim order may kindly be extended, my lord.
Order, yeah. Earlier granted is extended till next date of hearing.
Obliged, my lord.
ಇದನ್ನೆಲ್ಲ 23rd repeat ಮಾಡ್ಬಿಡಿ.
My lord, one request, my lord.
Yes.
Matter serial number 4, my lord. There's some urgency in that matter, my lord. May I request for
23rd we are repeating it.
Serial number 5, my lord.
Day after tomorrow. Grateful, my lord. Grateful.
Permitted to take notice on advocate for respondent. Meanwhile, matter has been posted on 24/2 before the trial court. That is the reason.
5. The counsel for the petitioner is also permitted to take notice on the counsel for the respondents in the trial court. To list on 23/2.
Obliged.
23rd, Mr. Angadi. Ella 23rd. Ella kariyak badlu 23rd.
Serial number 23rd.
What officer, madam? Serial number 3, madam.
What officer? ಹೇಳಿ ಮೇಡಮ್.
Madam,
7 and second list.
Serial number?
Serial number 3.
Serial number 3, Ravi Kumar.
ಹೌದು ಮೇಡಮ್.
Day after tomorrow ಬರುತ್ತೆ.
ಮೇಡಮ್
ಹೇಳಿ, ನಿಮ್ದು ಹೇಳಿ ಮೇಡಮ್.
7.
Serial number ಹೇಳಿಲ್ಲ.
7.
7 day after tomorrow.
Okay, thank you.
ಸಿಂಗಲ್ ದಲ್ಲಿ ಇದಕ್ಕೆ ಪಿನ್ ಮಾಡಿದ್ದೀರಾ ಅದಕ್ಕೆ ಇಲ್ಲ ಅದು ಒಂದ್ ಟ್ರಿಪ್ ಬಂದೈತೆ, ಇನ್ನೊಂದ್ ಟ್ರಿಪ್ ಇವಾಗ ತರ್ಬೇಕು, ಕೊಟ್ರೆ ತರ್ಬೇಕು, ಇಲ್ಲಾಂದ್ರೆ ಅವೇ ಸರಿ ಆಯ್ತವೆ, ಅವೇ ತೆಗೆಯೋದು ಹಾಕೋದು ಮಾಡ್ತಾರೆ. ಸೇರ್ಸೋದು ಇದೆ ಮೇಡಮ್ ಅಲ್ಲಿ.